It's now 10 o'clock and the inquiry is resumed. Can everybody hear me?
Yes, thank you, sir.
It is a large room today, and just to urge everyone who does participate, please remember to speak up so everyone will hear. So my name is Mike Warden, and I'm a Chartered Town Planner, and I've been appointed by the Secretary of State to hold this inquiry by Cooper Estate Strategic Land Limited against the refusal of planning permission. And I won't read out all of the description of development, but it's for development at land at Sandown Park and Tunbridge Wells, Kent. For those of you who are were not here last week on our Zoom session, we're just going to go through a few procedures which are slightly different today for our physical event, and it's good to see people actually that we met on Zoom last week, so it's good to see you in the flesh. Can everyone please put their mobile phones off or put them to silent? I wonder whether the council could just explain what the fire evacuation procedures are.
So if the fire alarm does go off, we all go out of these doors and down the main steps and outside the front double doors where we can meet and take a register.
And has council got an attendance list in circulation?
We will have, yes.
Thank you, that's great. And so everybody in attendance, if you just add your name and your details to the attendance list, that will be circulated. Thank you. It's switching between Zoom and physical settings, so it's a bit complicated, but today I'd like you to add your details to the attendance list, please. I've got the details of all the main parties, so you don't need to put those down. It's really for those people who are not part of the main party. This morning, I'm going to hear from Mr. Hughes, who wasn't able to join us last week, so just hear briefly from Mr. Hughes. And then we'll go into evidence on Greenbelt today, and we'll start with council, hear from council first, and then later we'll hear from the parents. We will take a mid-morning break. Hopefully it will coincide at the appropriate time in terms of proceedings, but just to say to everybody that, particularly to the witnesses, that if you need a break, please just say we'll take a break. Thank you. Excuse me, Mrs. Kirk, because I think we kind of gave you a late lunch.
I appreciate the sentiment.
Are there any matters, before we start, are there any matters that the advocates wish to bring to my attention?
No, sir.
No, thank you, sir.
No, thank you, sir.
Thank you. Okay, I just want one point was about conditions. I just want to know whether there's been progress on conditions. I'm not expecting, I don't want to go through them now, but I just want to know that there has been discussion since we met on Thursday.
Yes,
are we progressing on conditions?
Yes, things are progressing. We've received a response from the appellant this morning, which we're considering and will respond shortly.
Okay, thank you. Okay. You don't have to be firm on this, but when do you think you might be able to present me with a revised draft suggested conditions?
I imagine in the next couple of days.
Okay. Well, I'll leave them for Friday, obviously.
That
So I
won't
might
be a
need to
problem.
discuss them. Okay. Okay, thank you. Thank you very much. With that done, I will invite Ms. Lambert to introduce your.
Did you want to hear from Mr. Hughes first?
Oh, I'm so sorry. I forgot Mr. Hughes. So sorry, Mr. Hughes. Thank you, Ms. Lambert.
And thank you for making time for me this morning. Apologies that I couldn't be there last week. My name's Robin Hughes, and I've lived in the Sandown Park area of Tunbridge Wells for the past 28 years. My concern is if this proposal is allowed to proceed as it's currently, it'll open a loophole that will erode the green belt all around Tunbridge Wells. The title of the application speaks of the development of a care community and assumes a designation of C2. And later in the application, it even boldly informs us that the particular purpose removes the barrier of the site being on greenbelt. So by their own statement, C2 is important. It is the only reason they're allowed to build on the site. Now, I understand this is only an outline plan, but it is an outline plan specifically for C2. So it's not unreasonable to expect the applicant to outline exactly what they will be offering, over and above a normal development to justify the designation. They make no attempt, from what I can see, to explain what makes the 108 houses C2 units and not C3 dwellings. There are no references to wheelchair access, no mention of ramps or wider doors, no specifications defining lifts or weight-bearing ceilings or even low-level lights and switches. Far from it. Most are two-storey, with vehicular access away from the house. The application explains this away by stating that the core care facilities will be available in what it calls the main house, the communal building. The communal building estimated to be 2,485 square metres. So how much of this will be left for care facilities once it has accommodated the residents and visitors' restaurant, including associated kitchen, the communal lounge and bar, the swimming pool, the gym, the library, the hobbies room, and the activities room? It does refer to a consulting stroke treatment room, but fails to clarify whether that is for medical or spa treatments. The only specific reference in the care facilities in the communal buildings is the words ancillary offices needed to run a care community. So we have a main building that appears to offer little or no provision for care facilities surrounded by houses that do not appear to be the type of properties that people requiring care could live in. Those ancillary offices in the communal buildings appear to be the basis upon which the whole site is designated C2. The positioning of the site renders it unsuitable for the purpose stated, as it sits right next to a busy dual carriageway. Should anyone requiring additional levels of care be exposed to higher than normal levels of carbon dioxide and particulates? The applicant makes a case for the need for the provision of C2, but from as far as I can see, makes little attempt to actually meet that specific need. The designations, such as these, are open to debate, but luckily the applicant was provided with a comparison site to clarify the matter. Throughout the proposal process, the applicants have repeatedly pointed us towards Bramshot Place in Liverpool as their comparison site for matters such as traffic flows and usage. Their consultants, WSP, go as far as to state the same development ethos is proposed at Sandown Park site to provide a secure, self-contained and sustainable development. The similarities are indeed striking. For example, their community buildings offer a clubhouse providing restaurant, bars, snooker rooms, games rooms, library, health and fitness centre, medical centre with nurse, visiting doctor, prescription delivery service, and a community shop. The application for that particular site is listed on the East Hampshire District Council Planning portal as 23650/20 and dates from 13th of August 2013. The application is for a retirement village comprising of 96 apartments, 48 cottages and communal facilities buildings and associated garaging and parking. The word care is not mentioned. And there is no claim at any point that the site should be considered C2. In Liverpool, they didn't need it to be C2 because it was built on the site of the old King George's Hospital and was such brownfield. Personally, I agree with the applicant's consultants. If this proposal is granted as it stands, I think we will indeed see a development very similar to Bramshot Place phases 1 to 3. An over 55s lifestyle village for older folks who can afford to pay for their gym and spa memberships. It will do little to improve the care facilities around Tunbridge Wells, and it will rapidly follow by a necklace of similar villages on our green belt, exploiting the same loophole. If the applicants are earnest in their quest to provide care facilities the commitment to that endeavour should be baked into the approval process, because it's certainly not current. Thank you.
Thank you very much, Mr. Hughes. Mr. Jones, have you got any questions? Mr. Hughes?
Very short, Mr. Hughes. Go on.
Mr. Hughes, we'll just be able to. Sorry, I should explain. Once you present it, I might have some questions which I actually haven't at the moment, but also give the talent a chance to ask you any questions. Mr. Jones would like to ask you a question.
Hello, good morning, Mr. Hughes. Thank you very much for coming. Just so I understand, the main part of your objection is a concern that the development won't, in fact, be C2.
Yes.
Not
that it won't be C2, but it won't offer the facilities. We have a shed load of paperwork provided by your client. And in there somewhere, you would think it would outline exactly what the C2 is going to look like. And there isn't anything that I.
Thank you. Obviously, we're dealing with that at the inquiry, but assume that it is a C2 use, and the inspector as a local authority does accept it is a C2 use. Would you then object still to a C2 use on this site?
Are you committing that you're going to provide on behalf of your client?
I'm afraid.
Are you committing on behalf of your client that full C2 facilities will be provided?
Yeah, we're applying for C2, and the inspector knows the position that if we were outside of C2, we'd be in breach of the law. But can I ask the questions? That's how it works, I'm afraid. Can you answer my question?
If your client is providing full C2 facilities, then that's not a problem. You've met your.
Thank you. So, I understand you've got a note, the inspector's got a note of your objection, but if it is C2, then you would be then content.
If it's full conversion C2, I've got no problem.
Okay, thank you very much.
Thank you very much, Mr. Hughes. Thank you. Thank you very much. Ms. Simon.
Thank you, sir. By way of introduction to the inquiry, are you Tanya Kirk?
Yes, I am.
And in your proof of evidence, Mrs. Kirk, which is core document 8.11, page 1, is your introduction. You were instructed by Tunbridge Wells Borough Council in May 2021 to provide expert witness support in respect to this appeal. Then paragraph 1.1.2, you tell us that you are a director of Hankinson Duckett Associates, HDA, a landscape architectural and environmental planning practice. You have a BSc honours degree in biology and a postgraduate diploma in landscape architecture. You are a chartered landscape architect, a member of the Landscape Institute, and you have been a landscape architect for over 10 years. Is that all correct?
The majority of that is correct. As the appellants pointed out in their rebuttal, there is a typo at the beginning of it about my instruction. So if you look at Appendix 2 in the Greenbelt study, that typo isn't there, and I was instructed in February 2022 by Tunbridge Wells Borough Council. That's the only anomaly.
Thank you very much. Continuing with paragraph 1.1.2, HDA designs and implements landscape and master planning projects, carries out environmental impact assessments and landscape character and capacity studies. It advises on environmental aspects of commercial, minerals, residential and recreational development for private and public bodies throughout Britain, and it is a member of the Environmental Management and Assessments. All of that correct?
Yes.
Paragraph 1.1.3, your role at HDA, you've had considerable experience of landscape and visual assessment and landscape character assessment, working for public and private bodies. You've managed and carried out landscape character and landscape sensitivity studies for district councils. And at paragraph 1.1.4, you also tell us that you specialise in greenbelt assessment, predominantly on a site-specific level. You authored the Greenbelt study for the Vale of White Horse District Council in support of their local plan part 2, which was found sound in examination. And you've written studies for private developers, resulting in successful planning applications. Is that correct?
Yes, it is.
And then at paragraph 1.1.6 over the page, you tell us that the evidence you've prepared and provide for this appeal is true and has been prepared and given in accordance with the guidance of your professional institution, and you confirm that the opinions expressed are your true professional opinions. Is that correct?
Yes.
And just before moving off your experience, please, Mrs. Kirk, there was reference in the Landscape Roundtable to other work that you've done at Tunbridge Wells. HDA authored a document which was part of the evidence base for the local plan. What document was that?
There were two documents. One was the looking at major development sites within the AONB, and one was the setting study to propose major development sites in the AONB. One of which is within our core documents list, but the major development sites in the AONB isn't.
Thank you. And you've given evidence at appeal for Tunbridge Wells. Which appeal was that?
That's a Hawkhurst appeal.
Hawkhurst Golf Club. Thank you. Turning then to the Greenbelt, and there's been already mention of Greenbelt studies for the evidence base for the local plan, which is progressing at the moment. It's at stage 2 at the moment. And there is a suite of Greenbelt studies in the core documents from 05.21 to 05.23, which were undertaken by consultants LUC. Can you briefly explain to the inquiry what they are and the process?
Yes. I'd like the inspector, please, to turn to primarily to my proof of evidence appendix 2. That's my Greenbelt study.
And that's core document 08.11.02.
Yeah, correct. And on page 6 of that document, under the title Greenbelt Review, I've set out a summary of the 3 Greenbelt studies produced by LUC in support of the council's evidence base. So the Tunbridge Wells Borough Greenbelt Strategic Study, reference CD 0521, looks at the Greenbelt of the borough as a whole and put forward areas where a stage 2 assessment may be appropriate. So it looked at areas of the borough that related strongly to the purposes of the Greenbelt, and other areas that were perhaps smaller and more related to settlement that maybe required further assessment, and they were looked at in the stage 2 study. The stage 2 study, reference CD 0522, is a more detailed and focused review of parcels of land within and adjacent to the Greenbelt around the settlements in Tunbridge Wells Borough. The assessment is undertaken in relation to the contribution of areas of land to each of the 5 Greenbelt purposes. So for that stage 2 assessment, they were looking at parcels of land that were drawn to recognisable boundaries. For the purposes of this appeal, the parcel that the appeal site falls within is reference TW5. The Borough Council then, and LUC on their behalf, then carried out a stage 3 assessment of Greenbelt allocations, reference CD 05.23. This was a more refined assessment of harm based on draft allocation sites that the council were considering for release from the Greenbelt. At this stage, the appeal site was not considered as a draft allocation site, and so it was not formally part of the stage 3 assessment process.
Thank you. And then on your page 8 of this document, there is a table 1 setting out what stage 2 assessment of the parcels was and the level of harm that was caused by the release of parcel, the methodology in relation to what level of harm would arise in that study. And table 2, you've set out a comparison between TW5, which includes the appeal site, and then PE6, which is opposite, and PE1. Can you explain that table?
Yes, and sir, for your reference, at the very last page of my appendix 2, there's a map. It's an appendices to my document, and it shows on the map. It's a copy of figure 1.2 of the state of the assessment, and it shows the location and the level of harm for the 3 parcels that I'm looking at in the table. Are you able to find that map, sir? Okay. So for reference geographically, our site sits to the southwest of the A21, with the parcel PE6 to the north, and then parcels PE1 are also to the north of the A21, but to the south of Pembury. And what table 2 represents is the findings of the stage 2 study for each of those parcels, along with the overall harm rating given for each of them as set out within the assessment of harm at table 1. So what the table shows is that parcel P1 was given a low overall harm rating. Parcel PE6, which is the other side of the A21 to our site, was given a moderate overall harm rating, and that the parcel within which the appeal site sits was given a high overall harm rating.
Thank you. And then what exercise have you done following that?
Thank you. So as part of the planning application, and primarily set out within para 8.45 of the planning statement, which is on page 44, reference CD 0203. I don't think we need to go to it, but that's a reference for you, sir, if you'd like to check. There was some criticism of the council's Greenbelt study not being site-specific. So the council sought to remedy this through the provision of evidence on a site-specific nature. And then what I've done in this report is I've looked at the studies that were taken to date, and then in section 5 of my Greenbelt study, I then carry out a Greenbelt analysis of the site using the same methodology as the LUC studies. And if you could turn, please, to my page 11, paragraph 5.12.
Is this of your?
This is my Greenbelt study. So yes, this is CD 08.11.02.
And which page is it?
It's page 11.
Yeah.
And it's paragraph 5.1.2.
Yeah. Okay, I've got that. Thank you.
And the paragraph addresses the way that I've set out the methodology that I've used, so that I judge the methodology employed within the Tunbridge Wells Greenbelt studies to be fair and proportionate. For consistency, a similar method was used as set out within the stage 3 Greenbelt study, and the same assessment criteria and judgments will be applied. I then state that the key difference will be that the appeal site is not proposed for Greenbelt removal as part of the local plan. So considerations of boundaries and impacts from release of Greenbelt are not relevant. Instead, my assessment of harm will focus on openness and the potential effects of the appeal site development with regards to the overarching aims and purposes of the Greenbelt. So there is a slightly different tack taken with the appeal sites in light of the fact that different paragraphs of the MPPF are applicable. So this site, in contrast to the council's assessment, the council is looking at exceptional circumstances for release of Greenbelt. And therefore, there are paragraphs within the MPPF that look specifically at boundaries and the council choosing boundaries in order to release Greenbelt. The appeal site is not able to release itself from the Greenbelt through this application. It is, as we've set out, inappropriate development within the Greenbelt. So no change, the existing Greenbelt boundaries would still be in place. This is why I made the change, this is why I've made the distinction in my methodology. To all other intents and purposes, I look at the the contribution to the purposes of the green belt in the same manner, and I look at the openness to the green belt in the same manner. But if you cannot move the boundaries of the green belt, then your consideration of what is strong boundary features are much less relevant, because you've got an existing boundary feature that remains in play.
In your appendix 3, which is CD 81103, plan HDA 1, so the first plan that's within appendix 3. You can see on that plan the boundary of the green belt in relation to the appeal site. And you've explained to the inspector the point about boundaries in your methodology. Here we can see the extent of the green belt, we can see the boundary, and we can see the A21 on the eastern boundary of the appeal site. And there's much reference in the appellant's evidence about the A21 acting as a boundary, and there's a section in the rebuttal about boundary features as well. Can you just help, again, what is the relevance of that in the context of this appeal?
Thank you. So, sir, to my mind, the proposed development is not changing greenbelt boundaries. The paragraph 140 of the MPPF talks about boundaries through preparation and updating of the local plan. Paragraph 143 of the MPPF also talks about plans and it's not mentioned, boundaries specifically, and not mentioned in paragraphs 147 or 148, which are applicable to applications within the greenbelt. Notwithstanding that, and the boundary that exists, so the boundary to the western side of the site, which is the current greenbelt boundary, has been assessed as moderate strength by both myself and Mr. Gibbons. So moderate strength was set out in paragraph 3.1.10 of Mr. Gibbons' rebuttal, CD reference 0.51. And it's also referenced at paragraph 3.2.6 of the stage 3 greenbelt study, CD reference 05.23. Also in regard to the strength of the A21 as a boundary, I agree that the A21 in greenbelt terms would form a strong boundary to development. However, in the stage 1 greenbelt assessment, which is CD 05.23, at page 20, paragraph 4.20, it mentions that the A21 is not a separating feature when settlement is on both sides, and we can take you to the report. So to my mind, the council has looked at the overarching greenbelt at stage 1. At stage 2, they've looked at different parcels of the greenbelt and their contributions to purposes. What they've seen in stage 2 is that the land to the south of Pembury has a low level of harm, and the land to the north of Pembury has a medium level of harm, and the land within which the appeal site sits has a high level of harm. And what's happened is that through the local plan Reg 19, the council have sought to allocate sites within the P1 area, which has a low level of harm, and uses the A21 as a boundary, and also has allocated or is seeking to allocate the permitted site at Owl's Nest Oast, which is to the northeast of the appeal site. And again, the A21 forms the edge to that. So to my mind, it is clear that the council's view is to use the A21 as the boundary feature for sites at Pembrey and not for sites at Tunbridge Wells. Notwithstanding that, it's also my view that through this appeal, we're not at liberty to change the boundary to the site to the A21, and that we need to judge the site with regards to its existing moderate strength boundary, which is to the western side boundary.
Thank you. Turning then to the purposes, and we know from para 138 of the NPPF that Greenbelt serves 5 purposes, so we need to take each of them in turn briefly. Purpose A is to check the unrestricted sprawl of large built-up areas. And your conclusions on this are in your Greenbelt study, so back to core document 081102. And page 12 onwards. From page 12 onwards, you have a table for each of the Greenbelt purposes that you've assessed, is that right?
That's correct, yes. What I've done on these tables, they're on pages 12, 13 and 14, is I've given, for context, I've given the Greenbelt purpose that the table relates to. I've given the assessment judgment as set out in the stage 2 assessment, with the assessment analysis set out within the stage 2 assessment. And then I've provided my own commentary and analysis underneath so that it's clear which comments my judgments are relating to. So with regards to checking the unrestricted sprawl of large built-up areas, I've stated that the site is located in an area of the parcel which is both physically and visually separated from the settlement edge of Tunbridge Wells. And there are physical links to the countryside to the north and south, and visual links to the countryside to the south. And in my professional opinion, the appeal site relates more strongly to the countryside than adjacent settlement. And that if you then turn to the definition ratings within the stage 2 Greenbelt assessment, which is
0522.
Yes, that's correct. On page 22, that gives the definition ratings as set out. And I agree with I believe that the site makes a moderate contribution to purpose 1, which is over and above the assessment level given, which was relatively weak. Just because the site is close to the large upbuild area, but only to the western boundary, and that it has a stronger relationship with the countryside, due to the fact that you're not taking the site out of the Greenbelt, and therefore the countryside to the south of the site, but still within parcel TW5, is still pertinent. Also, TW5 is a larger parcel of land, and if you note, sir, if you look on the map, and again, maybe it's helpful to turn to a plan on HDA1 in Appendix 3, to the southwest of the parcel, the land abuts the development of Sandown Park, both on 2 sides, whereas the site is only adjacent to development on 1 side. So part of the parcel will have a stronger relationship with the urban edge than the site does.
So that explains the difference between your assessment in relation to this purpose and the LUCs.
Yes, correct. Mr. Gibbons in his pre, which is CD 07.11.01, came to the conclusion that the contribution to urban sprawl, or purpose A, was relatively weak. There were various reasons cited, including that the MPPF was not anti-development at paragraph 7.6.6, that the site is contained by natural features at 7.6.9, and that at 7.6.11 he states that the site is separated from countryside by wood, trees and landform. Also at 7.6.1 states that there's no urbanising features within the appeal site, but that's still, there's a relatively weak contribution to purpose 1 of the Greenbelt, which to my mind is inconsistent with the methodology set out within stage 2.
Can you just explain that? What do you mean by inconsistent with the methodology at stage 2?
So again, if we turn to the methodology at stage 2, which is, find it again, sorry, sir. CD 05.22 on page 22. It's the page number of the, on the page itself and not the PDF page number, I'm afraid. So if you look at purpose 1, it sets out a strong contribution, a relatively strong contribution, a moderate contribution, relatively weak and weak. And under relatively weak, it sets out that the parcel is adjacent to the large built-up area, relates more strongly to this than the wider countryside, or that it is not adjacent to the large built-up area. However, I think it's agreed that the parcel is adjacent to the large built-up area. And my view is that the parcel is adjacent to the large built-up area and either relates to both settlement and the wider countryside, or as a degree of separation for both. So I think that there's a relationship between the settlement, but there is also a relationship between that and the countryside. So I've judged it to be moderate.
Thank you. Purpose 2, your table goes from page 12 to page 13.
Yes, that's correct.
And can you help us with the differences between you and Mr. Gibbons in relation to this purpose, please?
Yes, certainly. The LEC study for this gave a relatively strong rating. My own assessment is that stage 2 study sets out the importance of the A21 in terms of separation, but it then goes on to assert that the small, and this is in my text a quote, that the small size of the gap and the connection provided by the A264 means that the open space, and to my mind, that relates to open land in Greenbelt terms, within the parcel also makes an important contribution to the settlement gap. That text isn't in the assessment text for the parcel to the north, PE6. The allocations set out with the local plan indicate that the A21 is likely to become the Greenbelt boundary feature to the south and west of Pembury, as I've already stated. And as such, the open land to the west of the dual carriageway, of which the appeal site is a part, in combination with the A21, will form the essential separation between settlements of Tunbridge Wells and Pembury. In contrast, Mr. Gibbons provides a judgment of weak or no contribution to settlement separation as part of the site. If we turn again to Mr. Gibbons' proof, which is CD 07.11.01. And then at paragraph 7, so please do stop me if you want to go to these. I'm just going to give paragraph references to look up later for speed, but we can go to them if you would prefer. So at paragraph 6.7.6.22, my apologies. Mr. Gibbons looks at the distances from the edge of the site to the inset green belt of Pembury. But then at 6.7.6.24, there's reference to closing of the physical gap to the hospital as an accumulation of this development on the site and development at Owl's Nest. And then it talks about only the land adjacent to the A264 being important at 7.6.2 and 7.6.28. However, there's no distinction within the LUC study about the land adjacent to the A264 or the land within which the appeal site sits. To my mind, both are equally important. And then so I would like to take you to Appendix 3 of my proof, again, which is the supporting plans.
CD 1103.
Correct. Thank you. And plan HDA 5. So both of these plans are extracts from the design and access statement that was submitted with the application documents. On the left, it shows existing built development, and the only addition that we've made is to label the appeal site. Whereas on the right, the changes that were made to the plan for the purposes of this plan are labels have been added to clarify certain points of my argument, but also the proposed development as set out within the approved application documents for Owl's Nest. The black outline of that building has also been added to this plan. The black outlines of the buildings within the appeal site were already part of this plan within the design and access statement. And we've referenced the pages of the design and access statement that the plans have been taken from for your convenience. Now, if you look at one, the first is without the development on the appeal site and without any development of the proposed development set out within the local plan at Pembury. Bearing in mind that the Owl's Nest application is now approved, regardless of the local plan status. And then the plan on the right shows the change to openness with the inclusion of the proposed development. And to my mind, this illustrates very well what would happen to the separation between Tunbridge Wells and Pembury by virtue of the degradation of that openness through development. I think it's very clear that the physical effects of the site on the openness of the greenbelt would erode the separation between Tunbridge Wells and Pembury, and that the distances between the buildings of the appeal site and Owl's Nest are only marginally different to the distances between the proposed development and the existing edge of Tunbridge Wells, such that physically, in terms of physical openness, they appear to be merging. So to my mind, the strength, if we go back to the wording of the purpose, which is how does the path of the site, I'm just trying to find it, prevent neighbouring towns merging into one another. And given that the stage 2 study asserts that Tunbridge Wells and Pembury are neighbouring towns, the site, to my mind, is key in preventing that merging from occurring, and that the open land between the A21 and Tunbridge Wells is the essential separation of open land, in particular, between the two towns.
Can I just ask a question?
Also.
I'm looking at, I've taken myself to the wrong plan.
Oh, sorry,
I'm
sir.
looking at HDA 5, is that the right plan?
Correct.
So there's existing built development on the left-hand side and cumulative effects on openness.
Yes, correct. While the plan titled openness, and I would like to come to this plan again when looking at openness, I believe that it helps visually to look at the spatial effects on separation as well. The openness of the greenbelt and the contribution to greenbelt purposes are separate but interlinked.
Can we just, sorry to interrupt you, but just so, just to help me here, then, in terms of this purpose, to prevent neighbouring towns from merging, and you're referring to this plan which shows the Peel site effectively in the gap between Sandown Park and Peel on the eastern side of the A21.
Correct. While I realise that they're not the two edges of the greenbelt, the purpose relates to the prevention of merging, and the fundamental aim is openness and permanence of the greenbelt. And if the greenbelt is not open, then the separation cannot be such that it would be if the land was open between the two towns. I think and hopefully we'll come on to it on openness, because I believe that that's the more pertinent argument for this appeal, because of the difference in how the NPPF looks at development within the Greenbelt and taking development out of the Greenbelt. We've looked at the purposes with specific reference to the commentary from the appellants of not looking at the site specifically. But there's reference in, and I can take you to it if you'd like to aid your understanding, there's reference to the harm to the Greenbelt or the harm to the openness of the Greenbelt from the hospital and the other built form that extends from Pembury in terms of physical openness. And to my view, if you fill an open gap of the Greenbelt with development, then by virtue of what the NPPF says in terms of not keeping land within the Greenbelt, if it's not open, you're closing the gap, regardless of whether the Greenbelt, you're weakening the strength of the Greenbelt in these purposes because the land is no longer open. And therefore the cumulative effect of development is to erode the gap between the two towns. Please do ask me some more questions if I'm not making myself clear, sir.
I don't want to your evidence in chief. I just want a bit of clarification for that. I will have some questions later.
Indeed, yes.
If Ms. Lambert continues to take you through your evidence in chief.
Yeah. I think the only other thing to say with separation is that it's my view, and this goes back to our discussions on landscape, that from sections of the Pembury Road, you can see both the hospital, you would see both the hospital at Pembury and the proposed development site. And as was pointed out in the rebuttal statement, I mistakenly referred to this as intervisibility when what I meant to say, and if you see it in the context of my sentence, which I can take you to, I'm talking about from the Pembury Road, the fact that you can see both would affect your perception of the gap between the two.
Where on the Pembury Road?
It's in that area of the zone of visual influence that we walked to yesterday. So. And on the bridge.
Which bridge?
The A21.
One of the things that's said against you in relation to merging is that Mr. Gibbons says that the hospital is not part of Pembury. What do you say about that?
So I agree that the hospital is not part of the inset settlement of Pembury. And I agree that there is a small gap between Pembury and the hospital. But to my mind, what's happening here is that if the site is developed, then the site in conjunction with Owl's Nest will close the physical gap between Tunbridge Wells and the hospital. And then there would be an erosion of the separation between Tunbridge Wells and the hospital, which would substantially reduce the physical gap between Tunbridge Wells and Pembury. I don't think it's as simple as measuring from the edge of Tunbridge Wells to Pembury and seeing how little of the or more much of the greenbelt is taken up by the development, because the development is not being removed from the greenbelt. So any effects that the development have are the same as the development already exists in the greenbelt.
Thank you. And then turning back to your Appendix 2, CD 81102, page 13 to 14 is your table on purpose C, to assist in safeguarding the countryside from encroachment.
Yes, so with reference to this one's much shorter. I've agreed that the appeal site has a degree of separation from settlement. However, if looked at in isolation, the appeal site has appreciable links to the countryside to the north and south. The judgment of moderate contribution I have judged to apply equally to the appeal site as it does to the wider parcel. And so I've got the same opinion as the stage 2 greenbelt study, which is a moderate contribution to this purpose. In contrast, Mr. Gibbons finds that the site has a relatively weak contribution to safeguarding the countryside from encroachment. Then at paragraph 7.6.41 of Mr. Gibbons' proof, which is CD 07.11.01.
Could you just repeat the paragraph number, sorry?
Yes, sorry.
Right.
It's 7.6.41 of CD 7.11.01. And there's a sentence, then there's a bullet point, and then underneath that it says, while there are no urban influences on the appeal site itself, and although the site has some separation from Sandown Park due to trees along its western edge, it then goes on to say significant urbanising influences exist adjacent to the site, although to my mind that's not applicable to the judgment of the site. And further urbanising influences exist to the east of the A21. And it's those wider influences that have talked to the judgment. So then at paragraph 7.6.43 on the next page, page 30, says it is clear that the appeal site relates more strongly to the settlement than to the wider countryside. And that I disagree with that fact. That's not. And I asked the inspector to consider his site visit yesterday and coming to his own opinion on that. And then Mr. Gibbons then uses a quote from the stage 2 greenbelt study. The parcel is adjacent to the large built-up area, which corresponds to the comments associated with purpose 1 of that study, not purpose 3. The quote from purpose 3 is different And you'll see that in my page 13 of my study, the quote is, the parcel has a degree of separation from both the settlement and the wider countryside.
Everything you want to say about purpose C?
I think yes, with I mean, I think the other thing, there's a talk about visibility, and I think Mr. Gibbons' proof relies on visibility a lot, although policy, and both of us in our, I think, proof and my Greenbelt study, in terms of Greenbelt, visibility and physical openness are separate but interlinked, and so to rely on one rather than the other is incorrect. So at paragraph 7.6.47 of this proof, which is CD 71101 again, and that is on page 30. Mr. Gibbons states that the appeal site it talks about the lack of visibility between the landscape surrounding the appeal site, but it doesn't talk, and then it says the appeal site sits within a strongly wooded setting and has little, almost no visual connection with the wider countryside to the north of Blackhurst Lane or the east of the A21, and limited visibility across the fields to the south. Well, my view is that there are open views of the site and the countryside to the south from the Sandown Park track, but also that there is, if you look at then page 17, footnote 67.
Page 17, Mr. Gibbons' proof.
Yes.
Page 17.
Sorry, yes, 17. Footnote 67, it says, in the context of Greenbelt, openness does not mean openness in terms of the characteristics of openness or enclosure, and wooded landscapes which are enclosed in those terms preventing views exhibit openness in terms of Greenbelt policy. So, so to my mind, if we're looking at the countryside, and the site is clearly countryside due to its it's outside, it's within the Greenbelt as it stands, so it's not urban, and that it has little influence of an urban nature, and it has connections to the countryside to the south, and I think to the north, because I consider woodland to be countryside, then it's clear that the site has a higher contribution than relatively weak. Am I still talking? I've been upset. Can you still hear me? All right. Sorry. Okay, good. I took a little bit thirsty, and I wondered if I was fading.
Thank you. We don't need to look at purposes D and E because the same conclusions are reached.
Yes, that's correct. Both myself, Mr. Gibbons, and the stage 2 assessment come to the conclusion that there was a relatively weak contribution to Greenbelt purpose D, preserving setting and special character of towns, and that purpose E has not been assessed within the stage 2 assessment, and it hasn't been addressed by myself or Mr. Gibbons.
So then openness, please. We know that the fundamental aim of the Greenbelt is to prevent urban sprawl by keeping land permanently open. In terms of openness, there seems to be agreement with Mr. Gibbons that spatially there is impact. What is your view as to the relationship of spatial and visual impact on the openness of the Greenbelt?
So, again, I would like to turn to my Greenbelt studies CD 08.11.02. And there are a number of paragraphs which talk about openness, particularly with reference to section 5.3, which is at page 14. At 5.3.1 is there's no formal definition of openness in the MPPF, but as a matter of settled law, that openness means an absence of built form. And there are quotes within Mr. Gibbons' proof to corroborate that. And the courts have confirmed that the openness of a greenbelt has a spatial as well as a visual aspect. And then at 5.3.2, the next paragraph, the proposed development on the appeal side would constitute inappropriate development within the greenbelt. The World War II pillbox is currently the only building within the site boundary, and the remainder of the site with respect to greenbelt is considered open land. And then at 5.3.3, I look at the quantum of development in terms of building footprints, and then we've spoken about heights of the buildings within the landscape section, so I won't go into that again. But that looks at the physical effects of openness. And then at paragraph 5.3.5, I look at the distances from the edge of the existing greenbelt boundary and how there would be effects on the openness of the greenbelt with respect to where development is placed within the site. And then at paragraphs 5.37 and 5.3.8, I look at visibility. So at 5.3.7, visibility is not the primary factor for determining openness. However, glimpses of the site and Tunbridge Wells Hospital are both available from the A264 in winter. But that there would also be clear views, and this is at 5.3.8 on page 15, sir, of the proposals from the track section of Sandown Park, Blackhurst Lane and footbridge over the A221. In contrast, so that would have a material effect on openness. And in contrast, there is limiting urban influence or intervisibility with the adjacent settlement within Tunbridge Wells. Existing visual influence of urban development within the site is limited. And the proposals would therefore extend the visual influence of Tunbridge Wells into the greenbelt up to the A21, thus reducing the visual openness of the greenbelt. So there's both a visual and a spatial effect on openness in my view.
What's your view about the relationship between spatial aspect and visual aspect, and whether you can have one impacting openness without the other?
I think you need to take, I think from my point of view, it's like landscape and visual assessment. The two need to be considered separately, although they're interlinked. So a lack of visibility does not cancel out an effect on physical openness. And that goes back to the footnote that I spoke about, and I can take you to other parts of my proof if that's helpful. However, yeah, I think if you can't see the development, there's still a material effect on openness by virtue of development.
Thank you. And then the inspector's already looked at your plan 5, and that plan shows the physical impact of the development.
Correct. Yeah.
Thank you. And then you set out just your final conclusions on harm on openness, or at your paragraph 5.3.9 in your appendix 2. You say demonstrable harm and significant adverse effects. Can you just help the inspector as to why you and Mr. Gibbons give different harm ratings to openness?
So when we talk about openness, Mr. Gibbons covers it in his proof, which is CD 011.01. At paragraph 7.5.2, which is on page.
Page 17.
Thank you. It states, in planning terms, openness of the greenbelt is generally accepted to refer to the lack of built development, although there are exceptions to this, and it's agreed that this is not one of those exceptions. And then at 7.5.4, he says, openness is capable of having both spatial and visual aspects. In other words, the visual impact of the proposal may be relevant, as could its volume. And then I've already taken you to the footnote 67, where it says open does not mean openness in terms of characteristics, and the enclosure, for example, the wooded landscapes, the development would still exhibit openness in terms of greenbelt policy. So then Mr. Gibbons talks about existing effects on openness at paragraph 7.5.11, and they're on page 19. And he talks about the developments that I've already spoken about, including the hospital and the Knockplatz Garden Centre, another development. But in his view, at 7.5.12, where openness of the greenbelt is already impacted by development, and in this wider sense, the perceived change to openness with the development of the appeal site would therefore be even more limited. So I draw the opposite conclusion. In my view, if the openness of the greenbelt is already impacted by development on the eastern side of the A21, but the land to the western side of the A21, including the appeal site, is open land, then the effects of developing within that open land would be greater than they would be if there was a wider area of open land between two developments. And then at 7.5.14, it says, in light of the above, whilst there would be an undeniable spatial change to the openness of the greenbelt, agreed, as a consequence of the appeal proposals, there would be limited visual change, and the perception of this change would be very small. And then he concludes that there would be a low level of harm to the openness of the greenbelt. So from having an undeniable spatial change, because there's a limited visual change, which I disagree with, because I think there would be visual changes, particularly from the untracked element of Sandown Park, there's somehow a low level of harm to the openness of the greenbelt. I don't understand that judgment. I disagree with it. So.
Thank you very much. And you say you disagree with it, but in relation to openness, at 7.5.15, Mr. Gibbons concludes low level of harm, and in relation to the four purposes discussed, he concludes low level of harm. So in any event, what does he find about actual harm to the greenbelt?
So the conclusion, although I believe the harm to the greenbelt to be much greater than Mr. Gibbons, both of us are still coming to the conclusion that there is harm to the aims and purposes of the greenbelt, even if in his assessment it is limited. And that contradicts the initial planning statement at CD 0203, paragraph 8.49, where it says that there's no conflict with any of them. So Mr. Gibbons and I are of the same opinion that there remains harm to the greenbelt. It's the nature and size of the harm that we're in disagreement.
Mrs. Kirk, those are all my questions for you. Is there anything else you would like to add before your evidence in chief concludes?
No, thank you. I think I'm okay, but did you have some questions? So.
I have just. Okay, I'll ask them now. I mean, Mr. Jones might do what's Jones will have questions, but just going back to when we looked at neighbouring towns, the purpose of 3 month neighbouring towns merging, and I think you kind of partly answered my question that I was going to ask you, but I'll ask it again. Is Pembrey Hospital part of a neighbouring town?
So I think to answer the question, Pembrey Hospital lies in between Pembrey and Tunbridge Wells, and Pembrey and Tunbridge Wells have been recognised as neighbouring towns. So Pembrey Hospital is not it's not inset from the Greenbelt, it's part of the Greenbelt, but it is recognised, and I think we just went to it within Mr. Gibbons' proof, it's recognised to have effects on the openness of the Greenbelt. And that there are other developments between the two neighbouring towns that also have effects on the openness of the Greenbelt, and that the addition of the inappropriate development of the appeal site within the Greenbelt would, to my mind, reduce the separation between Tunbridge Wells and Pembrey Hospital such that there's a blurring or merging between Tunbridge Wells and the hospital. But the perception, the public perception of the hospital is that it's on the approach to Pembrey. So while it isn't part of Pembrey and it is distinct from Pembrey, there is also a narrow gap between the hospital and Pembrey inset from the settlement. So I believe that, again, and I think I don't want to repeat myself too much, but it's my view that the lack of openness between the two towns and the cumulative effects of that encroachment into the Greenbelt by inappropriate development would adversely affect this separation between the two towns, and that the site itself plays an important part in, and going back to the Greenbelt, preventing neighbouring towns from merging. The wording is specific about prevention rather than whether it actually affects coalescence. And my view is that open lands to the west of the A21, that's the essential separation between the two towns. Does that help, sir?
Thank you. Just to be clear, in the context of the National Foreign Policy framework, is Pembrey a town?
So the Pembrey is a village. Greenbelt assessment methodology varies, and through the accepted different local plans set out, and as has been done with the LEC study, at the beginning of a Greenbelt assessment, they set out what they believe to represent towns in the meaning of local policy. And because Pembrey is a size similar to that of Paddock Wood, at the stage 2 level assessment, and because it's inset, the borough minded that in relation to Greenbelt, that Pembrey should be considered as a town. It is in the methodology for the stage 1 assessment. I'll just try and find you the reference where they set it out. Sorry, Sarah, I've set it out. I've paraphrased it in my CD 08-1102, my appendix 2, at paragraph 4.2.5. Section 5 of the report, referring to the stage 1 report, sets out the assessment criteria for each of the Greenbelt purposes. And it considers neighbouring towns to be Tunbridge Wells, Tunbridge and Paddock Wood. And then due to its size and location between Royal Tunbridge Wells and Paddock Wood, Pembury is also considered a town with relation to purpose 2. It's beyond my remit to comment on that approach, but it is quite wide. It's quite widely used that larger villages and things are considered to be towns in Greenbelt purposes in terms of assessment. But I agree that in terms of its actual status, it's not a town. Does that help you, Sam?
Thank you. Just a simple question about encroachment. What do you understand by the term encroachment as applied to the Plan Policy Framework?
My view, encroachment is introducing built form into an open landscape beyond the into the greenbelt.
Right.
Oh, sorry. It's the introduction of built form into the greenbelt, which would adversely affect the openness of the greenbelt.
In terms of encroachment, does that definition matter where it's particularly applied?
So, with relation to the countryside, for example, both the stage 2 study and my own evidence, again, I can look up I think I've been through this, so I won't go back unless you would like me to, sir. But the open land is deemed to, within the greenbelt, is deemed to represent countryside, notwithstanding landscape character terminology. And that inappropriate development within the greenbelt is therefore encroachment into the countryside. But then you look at the wider effects on how the land, that open land, relates to the wider countryside. And in this situation, there is both a spatial and a visual relationship with both the site and the wider countryside, in my view. So the both are relevant, one leads on to the other, but in my mind it's the physical fact of introducing built form into open land, the countryside, that encroachment in itself applies to purpose C of the MPPA.
Just thinking about the site and its relationship to the adjoining built area. What would you say about encroachment? Did you just define encroachment when you refer to openness and that and support form? But
so
what does it mean in relation to this particular site, would you say?
So this particular site, I think it is encroachment because the proposed development, it doesn't abut the existing boundary, it's separated from it because and rightly so, though the appellant was looking at retaining the woodland in between the built form and the urban edge. Well, suburban, but the existing limits to built development. So if you're looking at, if you've got development on, say, 3 sides of a site, the encroachment is less because it's infill, whereas there's only a settlement boundary to one side, And as you can see from my plan HDA 5, which we've looked at, the site boundary, it's only really to the southwest of the site that the site has a relationship in spatial terms with the existing limits to built development. And so what the proposals have done in terms of built form is jumped that edge, and actually the proposals are then encroaching into the open land beyond the limits to built development. I think it's material.
Thank you. Final question from me, just as a point about when you talk about visual openness, clarification, because you referred to you added the word winter into, I think it took me to a paragraph, and it might be 5.37 in the appendix that we've been looking at. It was.
And I'm talking about the visibility.
And so you talked about visibility not found back in terms of, I think you read it out.
Yeah.
And you put how the depth of the site of site and Tunbridge Wells Hospital are both available from the A264.
Correct.
I think you added the word in winter.
I have, yes.
So in reading 5.37, I should.
You should read
add
the
in
whole
word
paragraph.
in winter.
That you make your mind. My paragraph stands. In winter is when you would see the views, as discussed in our roundtable session, and I think that it remains that that's there. To my mind, it's the open views through all seasons that you can experience of the site at the moment from the track element of Sandown Park and from Blackhurst Lane, because are still material, because that would materially affect people's perception of openness. So it's a
But I should take it. I think what you said, discuss that you, in terms of visibility, the visibility element of openness.
yes.
You are now saying that it's terms of the site to be both available for the 264 in winter.
For that, yes.
And just is there anything you wish to say in terms of that seasonal aspect of that visibility then? Is there anything you wish to say?
I understand that is to my mind, a lesser point of my argument, that wider visibility, because to me the material fact is the physical effects on the openness, but also the visual effects from the vicinity of the site, because how people would experience the openness of the site as it stands at the moment would be affected from areas where you have full views of the site and experience it as countryside as at the moment. So I take on board your comments about, or your questions regarding seasonality. I think it's still pertinent for half the year, but to my mind, it's the spatial element of this and the visual effects on people experiencing the appeal site, which is by definition inappropriate development. So your experience within the site matters. It's not just the wider area. They're the key elements that I would like to draw your attention to. So.
Thank you, Mrs. Kirk. It's now 11, so I think we should take a break before moving to examination. 10-minute break, 50-minute break, Mrs. Kirk. I'm in your hands, really.
Yep, I think 10 or 15 minutes is fine. So either. Yeah.
And just so to help me, Mr. Jones, just remind me of how long do you?
I think in the timetable I've got until the lunch and adjournment and cross-examination. 11:30 now. I'm going to try and do that if I can, depending on the
So
answers.
by 1 o'clock.
By 1 o'clock, yeah, because otherwise we're not going to. If we start now, we're not. I think you gave us a warning last week. If we don't keep to it, we're gonna go off.
Yeah, okay.
It may mean that everything that Mr. Gibbons and Mrs. Kirk are at odds with, I don't explore, but that doesn't mean that we've given in or anything or changed the view. I mean, we explore with Mr. Gibbons, but I don't think I want to focus on some of the main issues. You've touched in your question, actually, your questions on some of those actually already.
All right, okay. So, it's just gone 25 past, so shall we break down, resume at 20 to 12?
Thank you, sir.
Thank you.
Outside.
Is everybody able to follow people at the back? Can you hear them okay? In terms of what
A little bit louder would be good. I think there was a problem, so with the windows, traffic going past.
If you wish to bring your chairs a little bit closer, then please do so without intimidating Mrs. Kerr. But if you wish to bring them a little bit closer to here, then or if you wish to move away from the window, that's a problem. As you are struggling to hear, just wave at me or something, or just let me know if there's a problem. So that's not the most ideal room, being a long sitting room, but it's what we've got today. Thank you very much. Jones.
Thank you very much, sir. Good morning, Mrs. Kerr. So just to let you know, we're going to be going over some of the topics I think you dealt with in chief and also answered the inspector's questions. So just to flag up, so we need the core documents, which you'll already have, I think, of your proofs, appendices, Mr. Gibbons, also the council's stage 1, 2, 3 assessment to hand, and I think that should be broadly okay. And then the topics we're going to be dealing with is looking at TW5. We're also going to be looking at your methodology, in particular, as you found out, your treatment of boundaries at stage 2, and why we're going to be suggesting that's a flawed approach. Indivisibility, I think now there may be a modicum of, I think you indicated in chief, maybe a degree of agreement, but we're going to then explore where that leads us on to where your approach to visual and spatial in elements and the purposes of Green Belt, when we come on to look at, and the inspector is asking you about encroachment and how you approach that. And we'll be touching, or perhaps now not so much as before in the light of the inspector's questions, on the issue of a coalescence of towns and your approach to the hospital site, Embry, and also the Owl's Nest. And also we'll be dealing with what you said in chief, particularly about the A21 not being a boundary where you have settlements on both sides of the Green Belt. And I want to challenge you a bit on that. So that's a sort of route map. So in terms of, can we just deal, and I said TW5, before we get on to methodology, can we agree? What the council did was stage 1, stage 2 assessments of sites that were under consideration, but those that were rejected were not subject to stage 3.
That's correct.
And so insofar as TW5 and the council's stage 2 Green Belt study, that was looking at a release for the whole parcel on the assumption it would be developed. So we were looking, council stage 2 was looking at TW5, wasn't it?
Correct.
So in terms of this site, and we'll come on to look a bit more closely, but just in terms of how much of TW5, I think we've got the statement of common ground, and we don't need to turn it up, but for your note, Parasa 9.34, this site would be about 23% of the area of TW5.
So I believe that's correct. However, I think there are other factors to consider rather than just the quantum of the.
I didn't suggest otherwise. We're going to come on and explore those. But can we agree that in terms of TW5 is a relatively small part of it?
So we can agree that it's 23% of it.
Well, we're not going to. I've got a tight timetable, so I'm going to suggest this with respect. An answer of yes or no. If you're not going to give a yes or no, say I'm not going to give a yes or no answer. And if you're arguing yes or no, you can by all means qualify it. But if you just don't answer the question at all, it makes life very difficult. So, I mean, in a sense, you know, I'm not trying to make you give an answer you don't want to give. You give your answer. But if you could be, so would you agree if I was to put to you that in terms of area, that was a relatively small area compared to the, so the site was relatively small compared to the whole of TW5, would you agree with that?
Yes, however, I go back to my same comments that may not be material to the assessment of green.
Well, you say may not be material. Can we agree this? It would be material, but there may be other factors as well. Or are you saying it's just the size, the relative size is not material when we look at the assessment at all?
I think when we're looking at effects of, I'm just going to pause there.
Yeah.
Sorry. When you're looking at the effects on the openness of the green belt and you're looking at the effects on the purposes of the green belt, then those are the things to focus on, not the size of the development.
Well, no, what I'm saying is, sorry, you misunderstand. What I've been asking you is, we're going to be looking at, and you've quoted what was said in stage 2 assessment by the council. Of course, that's in respect of TW5. Yeah, and then don't worry, we'll get into it. It wasn't, as we say, you've made a point, the appellants said it wasn't a site assessment, and we're getting to that. So when we're looking at comments or assessments that are made at stage 2, we have to take into account, don't we, that the appeal side is a relatively small part of TW5. I'm not saying, and you can then explain, you know, other factors may give greater weight to them or lesser weight. But when we're understanding TW5 and the comments that were made at stage 2, surely we have to take into account and adjust, or at least take into account as material that the comments are expressed in respect of the whole of TW5.
Yes, I agree that the comments are expressed. My comments are on the site specifically. The comments of the stage 2 greenbelt study relate to T-class or TW5.
Yeah, but you've referred to, and in particular, just so that I'm not, where I'm going to be going with that, for example, is when we look at TW5 and we comments that were made in the council's assessment in terms of the land next to Pembury Road. And that and the importance that that was playing, that was in comments of TW5. And I'm going to take you to that on the plan. I'm going to be suggesting we need to bear in mind where the location of this appeal site is in relation to the Pembury Road and those comments that were made in respect of the importance of TW5 as a whole. That's why I've just flagged this up. Okay, we'll go there in due course, just so that in terms of overall, can we agree this? You may say it's unacceptable and high, but can we agree this, that the development of the appeal site would be less harmful than development or allocation of the whole site in terms of greenbelt openness?
In terms of spatial
And visual.
Yes, but we're not looking at the whole of TW5. And in terms of,
So if we then, I mean, we can agree that you may say, and the inspector may agree, we'll wait and see, that it's unacceptably harmful, it's not offset by benefits, whatever. But we can agree this, that the development of this site, in terms of greenbelt openness, whether it's spatial or visual, is going to be less harmful than the development of the whole site. The whole, not the whole site, TW5.
Yes, however, when the council was looking at the whole parcel of TW5, they were looking at its removal from the greenbelt and just of that parcel. There wasn't an assessment of cumulative effects or an aggregation. So while I understand that in terms of physical openness, i.e. if the whole of parcel 5 was developed in terms of physical and visual openness, there would be more effect. However, if the parcel T5, for example, had been put forward within the local plan for removal and then subsequently the allocation at Owl's Nest had not been put forward, it would be a different case than we're looking at with regards to the appeal site.
I know you jumped again, and again, I'm trying to speed this up by keeping the questions quite focused. In terms of both spatial and, I mean, very simple, it doesn't mean you concede your case, but I just want to narrow the issues. The development of this parcel of land, both in terms of all the purposes of the green belt, let's say, and the development of the whole of TW5, it's got to be less harmful, hasn't it, in both spatial and visual openness.
In terms of spatial and visual openness, yes, however, that's why it wasn't taken forward for the stage 3 assessment. The council considered the allocation of this site to be too harmful to be considered for development.
Well, you're jumping ahead, you're thinking there's something always behind what I'm saying. The council weren't engaged in a comparative exercise. But anyway, I've asked the question, got the answer, we can move on. So can we look at the Greenbelt study, please, core document, stage 3 at, it's 523, sir, para 3.7.
Have a page number of that, please.
No. Hold on. Get it for you. 14, I think it is. 14. And just so you understand where I'm coming from in the terms of the question I was just putting to you, do you have the passage at para 3.7? The release of larger areas clearly has more potential to weaken the integrity of the green belt by extending into land that has a greater distinction from urban edges, by diminishing settlement separation, by diminishing the extent to which land remaining open land relates to the wider countryside.
Yes.
Yeah. So that's a context in which I was putting that question to you, and I take it you don't disagree with that statement.
I agree with the statement, but I would like to just point out has more potential to weaken the integrity of the
Yes.
green belt. I think there are circumstances that play on a site-specific basis. But the premise of the paragraph.
Yes, you're not suggesting this is some freaky site that that if you were to allocate the whole of TW5, it'd actually have less less weakening of the integrity of the green belt than if you allocated the site.
Sorry, I don't understand your question. I got caught up freaky.
Yeah.
Please could you repeat?
Well, you seem to be making a sort of linguistic point that the release of the larger areas has clearly potential to weaken the integrity, but in this case, it might not occur. Is that what you're suggesting?
Correct. So I think there are certain purposes of the green belt that within the parcel the site has contribution to. And I think in the context of
Do you remember the question that I'm asking you? I really don't want to spend too much on this. It's simply a question that was in the context of, you would accept, wouldn't you, that the development of the site would cause less harm to the appeal site, to spatial and visual openness of the green belt than the development of the whole of TW5.
So I think I believe I've already answered.
Well, so what's the answer?
Yes, but with the caveats that I mentioned earlier.
Well, I don't understand the caveats, but what are they?
In that you need to look at the point of this is to look at the site, the appeal site specifically. So
Sorry, no, you're going on to another question about the appeal, which we're going to move on to. I'm talking about the comparison.
I've answered that. Yes.
Okay, well, that's not a caveat to the answer to that question.
I then try to explain it, but then
You don't have to keep restating your case every time I answer a question. That's not a caveat.
So I'm confused because I feel like you're asking me the same question and I've given you the answer and then I've explained why my answer is what it is. And then you've asked me the question again and asked me to, so.
I'll move on. It's not what I've done. Okay, so can we then look at one of the issues which is touched on in the passage we just looked at stage 3, and where we just looked at the quotation where there was reference to how the remaining open land relates to the wider countryside. Can we also go to your Greenbelt assessment, paragraph 2.1.7.
That's on page 2, yes?
Yeah. And could we also then just have, again, the council's Greenbelt study sheet for TW5, which there is a core document 2205. Just let me know when you've got that. 052205, core document 52205. Let me know when you've got that.
I have that.
Yeah. Thank you very much.
And you were looking at paragraph 2.1.7.
Yes. Where you're quoting sub-area PE4, yeah, of the council sensitivity area. But I just want to take you to more particularly the Greenbelt study sheet for the TW5, and that's under the heading relationship between settlement and countryside. You've got that?
Yes.
And then it says the parcel, and this is referring to TW5, isn't it? Yes. Forms a major part of the narrow gap between Tunbridge Wells and Pembury. So it's focusing on Tunbridge Wells and Pembury, correct?
Correct.
The A21 is containing tree cover, which prevents any intervisibility between the two settlements, is a key element in settlement separation. Do you agree with that?
I agree with it to a certain extent. However, I think that the next part of the sentence, but the small size of the gap and the connection provided by the A24 mean that the open space within the parcel also makes an important contribution.
Yeah, we'll come to that. No, the reason I've stopped, and I wasn't intending to, it's what you said orally about the A21, in this section, no longer being recognised as a boundary or barrier. Do you remember that you said because there was settlement, there was Greenbelt on either side and settlement up to it, or development up to it. But it's recognised, isn't it? The A21 is recognised in the Greenbelt study, both here and elsewhere, as forming a barrier or boundary.
Correct, but it also goes on to state that the open land adjacent to that particularly to the west, which our site lies within, is important.
So contrary to what you said, I just want to take it in stages. In oral evidence, you were not meaning to suggest that the A21 no longer can be regarded as a barrier in greenbelt openness terms.
So my point is that, so in answer to your question, yes, currently the A21 is a barrier in terms of greenbelt. My point being that if there was development to both sides of the A21, then the study talks about other areas of the A21 where settlement is on both sides, and that the A21 in those circumstances is not sufficient to be separation.
Okay, we'll just take that stage by stage. I'll come back. You mentioned elsewhere in the study, and I'll just make a note, come back to that. But let's, so you're saying for the future, so then I don't want to leave, we say, but the small size of the gap, and you wanted to emphasize, and I wanted to take it to it in any event, the connection provided by the A264. So if we're looking at the 264, which is Pembury Road, isn't it?
Right.
And I know the inspectors walk across it, mean that the open space within the parcel also makes an important contribution to the settlement gap. And there's a difference between you and Mr. Gibbons, and the inspector can see on the site. Mr. Gibbons is saying, and of course we know that we've established a moment ago, the Greenbelt study was looking at TW5 as a block, and it doesn't condescend to say specifically the open space within the parcel also makes an important contribution to settlement gap. Mr. Gibbons gives evidence, and the inspector will form a judgment, obviously from going on the site, that it's the fields immediately adjacent within TW5 to the A264 that give that sense of openness when you're driving along that A24. You won't really be able to see the appeal site from that perspective, will you?
In summer, I agree. However, I think that the visual element from the A264 is not the only consideration in terms of the relationship between settlement and countryside, nor does it relate, is it in isolation how you should look at encroachment into a gap. And I don't see, while I take your point that we're looking at TW5 within this assessment, there is no text in the assessment to identify areas of higher contribution to settlement. It's an inference on your part, to my mind. It says that the open space within the parcel, it doesn't say the open space within the southwest parcel or the southeast, sorry.
No, I agree. I mean, I think it's your firm's work, isn't it?
No, it isn't.
Oh, it's not your firm's work. Well, anyway, it's not us. But what we can agree, therefore, is Mr. Gibbons is giving, as you are, his expert appraisal, looking at that, and the connection that's highlighted on the A264 there, and the open space within that makes the important contribution. He says is the fields immediately adjacent. You agreed during summer, but
no, sorry, I was answering your question on whether you could see the fields adjacent more than you can see the site. That I agree to in summer,
right,
and in winter. However, in terms of the contribution to the separation or the relationship to the settlement, then Mr. Gibbons and I have differing opinions.
So in terms,
there's a spatial, I said this earlier, there's a spatial context.
Yes. And you've at various times said that Mr. Gibbons ignores spatial, which he doesn't. But the question then is really, what role do you see for visual in terms of why do you think highlighting the connection provided by the A264, why do you think they've highlighted then that that parcel as an important contribution to settlement. If not, it's how you experience it visually.
Because the A264 is the point at which you cross from Tunbridge Wells to Pembroke.
So in terms of the weight to be given to looking at the contribution, do you say any weight is given to its visual, or is it irrelevant?
Oh, I see that weight is relevant. Visual is relevant, spatial, to my mind, is more relevant. And when we're looking at the site specifically, then we need to look at the context around the appeal site as it is now, and not just when this study was taking place.
And in terms of your own visits, just to be sure, am I right in understanding you carried out your assessment in winter? And until the site visit, you hadn't gone and carried out a summer equivalent. You've been on the site visit yesterday.
I have returned to the site in summer prior to this appeal, but it wasn't prior to the submission of my written evidence.
And in terms of carrying out assessment, we haven't got any further assessment where you've gone to various viewpoints to see whether they can be seen or not. We don't have that before us.
In winter, yes, we do.
In summer?
In summer, no, we don't. I've looked at Mr. Gibbons's photographs and evidence. As we do.
So just before we leave that aspect, in terms of, and you'll have seen the in terms of the site, I think in the green belt assessment, yours at para 241, just for the record, acknowledges that the site's located on a ridgetop plateau and is relatively flat.
In my green belt assessment?
Yeah, 241 if you want to look. Yeah, it's
I say the northern field is located on a ridgetop plateau and is relatively flat. And then the northern section of the southern parcel is relatively flat. However, the ground then falls away to the south and east in an undulating nature.
Yeah. And that's falling towards the Sandown, isn't it?
No, so that's falling towards Pembroke.
Pembury Road, sorry.
Pembroke Road is on a higher level, so it falls towards a valley feature that lies between the sides.
Yes,
and
that's
Pembroke
right.
Road.
You're on Pembury Road and you look down, and certainly we agreed you can't see the site in summer, and then we have Mr. Gibbons' evidence and the inspector make his judgment about any winter glimpses, of the site.
Yes, but the inspector will make his judgments. Yes, that's not for me to.
Yeah. So could I then just on approach then, just so that we deal on a approach in terms of your 1, 2, 3 stage, and you fairly acknowledge that the different approach you take when you say you carried out stage 3 assessment from the council's approach on the plan is towards boundaries. And your position, as I understand it, is because we're not looking at a local plan review, the site won't be taken out of the green belt. Therefore, you don't focus on boundaries. Is that right? That's the difference. And it's in your, you took us to in chief, the passage where you explained that, yeah?
Correct, it's explained.
So 512. It's paragraph 512.
Correct.
Okay. So can we just take a step back in terms of the relevance of boundaries? You're quite bold in 5.12 and you stick by it in chief. that you consideration of boundaries and then you say an impact is from releases. I'm interested in boundaries are not relevant to the assessment the inspector has before him. That's right, isn't it?
I consider that as part of this appeal, there is no ability to change a greenbelt boundary, such that the strength of a boundary can only really be attributed to the existing boundary because there is no proposed boundary.
So you say, just so that I'm clear, that when we are looking then at the site and any boundary issues, you say that's not relevant because we're not looking to release the land from the green belt. So it's not relevant to the inspector's assessment decision he has to make.
Correct. Notwithstanding that, there are issues with the boundaries of the site if he was choosing to look at that, but it's my belief that no, the boundaries are not relevant.
Okay, so I mean, when we are looking, aren't we, in terms, we obviously, as you know, our case is that boundaries are relevant to look at. And when we're looking at to see what impact, and when we come on later to the purposes of the green belt, we are going to be looking, aren't we, on issues such as encroachment. We're going to be looking at the extent to which there is coalescence between neighbouring towns and matters such as that. But we'll come on to that in a moment. But can I just explore your approach to boundaries? And if we go to your green belt assessment at page 12, and it's in the first table under purpose A, when you so if we just turn that up, which is in your appendix 2, isn't it?
Paragraph 5.2.3, first table.
Yeah, paragraphs 5.2.3, and you've got your comment there. Yeah, so I just wanted to test how consistent your approach has been, because where there you discuss woodland and trees, you note that the A21 is not seen from the site, is not relevant in green belt terms, and creates a strong boundary.
I don't say about, sorry sir, I don't understand, I don't say about it not creating a strong boundary. I say the A21 lies in cutting for most of the eastern site boundary, referring to the appeal site. And while the dual carriageway is audible, it does not intrude upon the site visually. I don't talk about the boundary of the A21, sorry sir.
So there you're not, you say the appeal site is located and the parcel is both physically and visually separated from the settlement edge of Tunbridge Wells by woodland and trees.
Correct, that's the existing greenbelt boundary.
The A21 lies in a cutting for most of the eastern side, and while the dual carriage is audible, it does not intrude upon the site visually. There are visual links to the countryside to the north and visual links to the countryside to the south.
Correct. The methodology at stage 2 is looking at what interrelationship there is with urban influence and influence the countryside. I haven't referenced boundaries.
But you're talking about the existing boundary there being important.
Yes, because that's the only boundary that we're considering. It's an existing boundary. We're not moving it. So
yeah, but
this is important. We're going. The development is going sprawling, encroaching beyond an existing fixed greenbelt boundary.
So in just so I understand your position in terms of boundaries not being relevant, you do say the existing greenbelt boundaries are relevant in assessing the harm to the openness of the green belt?
Yes, in terms of inappropriate development, because you can't move the green belt boundary as part of this appeal.
Yeah, but we're looking at this as an assessment of the harm to the green belt. I understood stage 2 was an assessment of the harm to the green belt.
I think, sorry sir, are you talking about my assessment of purpose A, or are you talking about boundaries? Because with regards to purpose A, I haven't talked about boundaries. I've talked about physical and visual separation from the existing limits of the built development. And when I say boundary, I refer to it in the context of the site boundary and the site vicinity, and not in terms of green belt boundary.
I mean, the position isn't all the boundaries important in assessing what is going to be let's stay with visual impact of a proposed development on the green belt?
So I think, with all due respect, there is a bit of a muddling here. In terms of relationship to the urban edge and relationship to the countryside, I talk about the site boundaries and the vegetation on the site boundaries. In green belt terms, I think the green belt boundary that we are looking at is the existing green belt boundary on the edge of the limits to built development.
And that's in the yes.
In answer to your question, site boundaries are important in determining how you would perceive the openness of the site in visual terms, and how you would perceive whether it is countryside, open land, and how you perceive that relationship with the edge of Sandown. But that doesn't translate into those boundaries being appropriate as a green belt boundary in the terms of this appeal. That's more for the local authority.
No, I'm focused on all the inspectors. You've said that boundaries are not relevant for the green belt assessment of harm that this inspector has to make. I'm putting to you, and I'll make submissions to the inspector, that as a matter of interpretation of policy, it plainly is. And when you're coming on to look at what the level of harm is, let's just say visually or even spatially, as you've just, I think, conceded, it is relevant to look at the various physical boundaries of the site when looking at, as we'll come on to, whether there is coalescence between towns, whether there's encroachment of the countryside, how that is perceived is capable of being influenced by the physical boundaries of the site.
I think again you're getting the matter confused. That my point with regards to not assessing greenbelt boundaries is that in Mr. Gibbons' evidence, he talks about the A21 being a stronger boundary in greenbelt terms than the existing greenbelt boundary which exists. So there's a differentiation that, sir, I hope you will make between using the terminology with reference to greenbelt boundaries, but making a wider assessment about field boundaries, tree groupings, and woodland, reference to the site boundary for geographical purposes, and how that reflects on the assessment of contribution to the purposes of the greenbelt.
Okay, so there are two things that I'll do with very quickly. First of all, can we agree, for the purposes of assessing harm to the greenbelt, the boundaries of the site are capable of being relevant to that assessment? That's point one. That was my initial question.
In terms of, yes, however, that's in terms of vegetation and your perception of those boundaries, and it's, in my evidence, it's clear that it's not with regard to the stage 3 assessment of greenbelt boundaries.
Well, come on and see, because what you can't do then is, drop the an element of the assessment out. So we're agreed that, notwithstanding the point, which I think is not at issue, that we are not in a EIP and we're not going to be declassifying the land as green belt. we're focused on the assessment the inspector has to do, and we're agreed, I think now, that the physical boundaries of the site are relevant to his assessment of harm for the development, both spatially and visually. You may have a different judgment to Mr. Gibbons about it. Don't go, please, back on that. I just need to know that there's agreement that it is relevant.
I agree that what is at the site boundaries or the lack of site boundary is relevant, as is other factors within the wider landscape.
Yeah, you don't, as I say, you don't need to state your case every time. I just need to know, because I hadn't appreciated that you agreed that before. So that may be. Can we go to on stage 3 then, in terms of the council stage 3? If you can just take stage 3, paragraph 3.25. And the core document references CD 523. Paragraph 325. I'm sorry. Page number 18 and 19 in the printed off version. Don't know if it's different on PDF. And then there's a rating, isn't there, of a 326, strength of boundary features.
And this is with regards to proposed new greenbelt boundaries.
That is the stage 3 assessment on the sites that the council were taking forward for removal for the green belt. Stage 3 of the council's assessment.
Yes, correct.
Yeah.
And then at 3.25 it says stronger boundary features are considered to have more permanence. So it's with regards to the MPPF and the requirement for the council to look at boundaries when they're removing land from the green belt.
And it says they represent a stronger physical barrier, some than others. The following provides an indication of strength attributed to more different types of boundaries. Strong boundary features considered to have more permanence. And then progressing from the urban area, the cumulative impact of multiple boundary features will increase distinction. The next paragraph.
This is going back to my point in my brief where I say that this can't be a consideration of this appeal because we're not changing the greenbelt boundary. This is specifically related to greenbelt boundaries. And so the point of reference for me for this document is the second bullet point where we're looking at moderate boundary, because that's the agreed position between Mr. Gibbons and myself for the existing greenbelt boundary pertinent to the site.
And just so I understand before we go in, you say therefore, for example, let's just put in terms of encroachment, whether the site has a strong or weak boundary is not relevant to what the inspector needs to look at in terms of the purpose of the green belt, in terms of encroachment in the countryside.
In terms of encroachment, to my view, I think that's
Can you just answer the question before? And if you say no, it's not relevant, then I disagree, but I can move on. I'm just putting to you, is it really right to say that the strength of boundary features is irrelevant to the exercise in this context, greenbelt boundary features that the inspector has? For example, and I just take as one example, and if we have time, we'll look at others, but the issue that the inspector, we agreed, does have to look at as encroachment into the countryside.
So please could you clarify whether with this you're talking about with regards to the existing greenbelt boundary, which for the purposes of this assessment has a moderate.
No, I'm looking at a bound. This gives indications of boundary types that would make good permanent greenbelt boundaries. Yes, we agree.
Yes, however,
Right.
we're not changing the boundary.
Yes, we know that. So,
So in terms of encroachment, we're looking at a moderate boundary and we're taking development beyond a moderate boundary. So yes, it's relevant because we've got a moderate boundary, but whether there is a stronger boundary in a different location is not relevant. It's
So
not relevant
if
because
you-
we're not changing the boundary.
so if you have a site that forms a clearly defined boundary, that is not, so you've gone across your moderate greenbelt boundary, yeah? And you've got a site which of itself creates a strong boundary, visibility, all those sorts of things. Is that relevant or irrelevant, the strength of that boundary, to the question of encroachment into the countryside?
So are you talking about the appeal site specifically?
Correct.
So in terms of the appeal site specifically, I think, no,
Well-
we're looking at the existing boundary. The relevance of the A21 is pertinent to urban influence.
You're just going to go back on the appeal. I'm
But
talking
also
about the
boundary
principle.
to the south of the
The
site is
principle.
entirely open. So even if you were to take your view that boundary is important, you still have an open
Right.
boundary to the south. But
Okay.
I don't think it's relevant.
You don't think it's relevant. That's fine. We disagree, but I just need to know. So, let us then look just briefly then on the site. The two pieces of copses. One is north to Knightswood, and you've referred to them in the Greenbelt assessment 2.4.3, your Greenbelt assessment 2.4.3. And we've got,
For the inspector's record on a plan view on HDA 5, these are labelled
Yeah.
as the gap between proposed development and the edge of the green belt.
yes, on your HTA 5, yes, it's right. Yeah. So in terms of that, we can also see that there's well, you want to call it a breach or whatever, or connection by the Sandown Park, the road to track, yeah?
In the
Becomes-
process,
Yes.
yes,
Yeah.
although it's narrow.
And in terms of site, that northern, the northern boundary to the site, would you agree that I just want to talk in site terms, because I know you say it's irrelevant for the green belt, but just in terms of boundary, there would be a strong boundary, wouldn't there? There's the woodland in Robinsgate Wood and beyond.
So am I understanding that you would like me to talk about the northern boundary in terms of greenbelt, even though I have?
Yes.
You
Yeah.
don't think it's relevant?
No, I don't. I think it's relevant. You don't think
I
it's
don't think
relevant.
it's relevant.
So you're saying, but I want to know your comments. The inspector will have a note. You don't think it's relevant, but whether or not, that means whether you agree with us, so we can narrow the issues. That if it were relevant, we can agree that it would be a strong boundary in terms of delineating the site. You, and the inspector's got your point. You say it's irrelevant.
So, yes, it would be a strong boundary and it's reflected in the parcel boundary of TW5.
And we see that in the stage 3 Greenbelt assessment, and picks up those features, doesn't it? And I know, don't worry, I know you disagree that this is all relevant, but we can agree that's a strong boundary. And the same thing would be on the eastern boundary, a similar thing, isn't it? You've got, again, you and the inspector's got a note, and I won't suggest anyway, you say this is all irrelevant, but in terms of actual boundary creation, we've got the A21 dual carriageway, haven't we? And that's a strong boundary feature.
Yes, in terms of
Yeah, and there's a change in the land form because you've got the cutting into the A21, but A21 is, yeah.
Correct.
And that creates a distinction, doesn't it? And again, this is all on the caveat, you don't agree that any of this is relevant, but I hope to persuade the inspector it is, so we can then know. And so that's strong. And then there's also woodland, both along the A21 embankments and to the east. And that contributes to what would be a strong boundary.
And to my mind, that is pertinent or relevant to Part C of the Greenbelt purposes, because it retains the rurality. You know, it's the contribution to countryside. You see the countryside, not the road. In terms of your question, the A21 again to the east is in the Greenbelt study LEC, and it's considered to be a strong boundary. But as we've noted, I don't agree with that, the use of that for the purposes of.
I know we've got that, don't worry, I won't. I will
So
get.
I'm unsure why I need to talk about.
I'm afraid that's one of the problems of being a witness. You have to answer questions you don't want to answer sometimes, unless the inspector. So we can. What we are trying to do is just narrow the issue. I know I'm not going to get you to agree that your assessment was wrong at 512 on the southern boundary. Yes. Now, what do you want to say about the southern boundary? Shall we go through that? Okay, so on the eastern end, we've got the area of woodland, including the ancient woodland that the inspector was seeing paced out yesterday, I think.
Correct, that's part of the eastern boundary.
Yeah. Well, that's the eastern end where it depends. Eastern end of the southern boundary, isn't it? Sort of on the southeastern corner. And then in the centre you've got some thinner woodland, haven't you? Well, the inspector would have seen this, which is sort of a moderate boundary feature if we were taking the Greenbelt boundary code, which I know you don't take. It would be moderate.
I'd like to point out that woodland is thinner than the woodland that is the existing Greenbelt boundary to the west.
And
then there's a gap.
It's about 20. Well, the inspector would say it's about 20 metres wide, isn't it?
Experienced it, yes, which is a weak boundary. So you
Well,
want a moderate and a weak boundary to the south.
Well,
and that would be one of the reasons why the parcel wasn't subdivided, because they were going to strong boundaries.
So, I mean, we say it's moderate, you say that bit of it is weaker, but there's moderate with the, where we say it's strong, ancient woodland. And then there is a weak boundary on the western end, isn't there? That's a weaker boundary, there's no clearly defined.
To clarify, south to the south. And
Yeah,
south
on the western end.
edge,
Yeah.
I believe is moderate towards strong, because you've got the tree copses that we were talking about.
Yeah.
And then you've got the copse the nursery that, excuse me, sorry, I'm trying to speak, thank you, sir. To the northwest of the site boundary comes into the Greenbelt, and there is that woodland that surrounds the nursery that's in the Greenbelt. So to the northwest it's strong, and to the west it's moderate.
Yeah, I mean, Mr. Gibbons is just, sorry if that disrupted you, we're just making sure we're not cross purposes. We're looking at the southern boundary to the site, which I suggest to you is moderate in its centre, where you've got the woodland that the inspector saw 20 metres or so separating. Is that agreeable?
Correct.
And then on the southern boundary, on the western side of the southern boundary, we would accept it's a weaker boundary because there's no clearly defined physical boundary features. But that's something we're looking to, that's a corner, So we're looking to plant to close the gap and reinforce the green boundary. Yes?
That's something that you proposed on.
Yes. Yeah. And certainly, and I know you don't like stage 3 being applied in this way and got the caveat, but when the council is doing that, they have taken into account when they've been deallocating sites or changing the boundaries, when they've looked at the boundaries, they've taken into account at the allocation stage, as we can see in stage 3. Subject to the caveat you say it's irrelevant, but they've taken into account that sort of proposal for mitigation as part of the stage 3 assessment.
That reflects the
Change in the
paragraphs in the MPPF,
Yeah.
which ask that councils consider boundaries.
Yeah.
You know, paragraph 140, greenbelt boundaries should only be altered through the preparation or updating of plans. And 141 and 142, when drawing up or reviewing greenbelt boundaries, the need to promote, etc., plans should give first consideration. So yes, it's entirely appropriate that the local authority should look at boundaries.
Yeah, it's not the question I was asking, because we know the difference between us, but in terms of, we can agree that when you're doing that, you also look at the mitigation that's proposed in the assessment.
Right, but Mr. Gibbons' study hasn't looked at mitigation either. It's not mitigation in his approach regarding greenbelt.
No, but I've put to you the assessment has taken it without the mitigation, but we know that on that southern western weak boundary, there is proposed to be mitigation. So if it's big if the inspector were to look at boundaries, part of his assessment of harm, it would be reasonable to take that proposed mitigation into account.
Right. I agree that the inspector should take the proposed mitigation as put forward in the application into account when he's considering the case as a whole.
Okay, thanks, that's fine. Okay, so we can leave boundaries, and I think, yeah, please do that. Divisibility, and I want to go back to, please, a point raised. I think I can deal with this much shorter now, so thank you for your questions. With the purpose of purpose B of the green belt, there is no interdivisibility, is there, between the site and the village stroke treated as a town, Pembury, is there?
Between Pembury and the site?
Yes. No, thank you. And there is also no interdivisibility between the site and the allocations to the south of Pembury.
No. No, I'm certain with regards to the ones that are within the, I was just pausing because I was trying to think of the one at Tesco, but I agree, there's no interdivisibility.
Thank you. And I think also when there's no interdivisibility between the appeal site and Owl's Nest Wood, which, as the inspector will have seen, is in the woodland east of the A21.
There's no current interdivisibility. I haven't carried out a visual assessment for the appeal, the approved landscape at Owl's Nest Wood. Okay,
because the reason I'm asking this is because of your position on when we come on to look at the merging of two towns, and you've got the evidence from Mr. Gibbons in his rebuttal about interdivisibility.
Yes.
Yeah. So he's carried out those exercises. So can we agree this? I think you've agreed Pembury Hospital's not in Pembury and not in the development limits of Pembury, is it?
I agree, it's not in the development limits.
And it's not in an insert in the green belt, is it?
It's not in an insert in the green belt. However, it is in the green belt study produced by LEC, the proof of evidence produced by Mr. Gibbons and my own evidence, it is agreed to have an effect on the openness of the green belt.
It's there, isn't it?
Yeah, exactly.
And we'll come on to the question of encroachment in a minute. Owl's Nest allocation south of Pembury. But the Owl's Nest, is that in Pembury built development limits?
No. It's permitted now as well. It's not just an allocation.
And can we? I think it's agreed, isn't it, that none of these features, Pembury Hospital, Owl's Nest as permitted, and indeed Pembury itself, are within the agreed ZVI.
The ZVI is looking specifically at the site. Yes, the
Yes.
site and the visibility between those. That's
Yeah.
part of that. But you know, Owl's Nest is not publicly accessible land, so I don't know if Mr. Gibbons went to Owl's Nest to test it. But I'm just
going through it can deal with it, but it's an agreed matter, isn't it?
So
Yeah. Well, this zone of visual influence is agreed, isn't it?
yes, correct. But the zone of visual influence relates to publicly accessible views and landscape and visual terms.
Okay.
But
So
yes,
you've got a query about Owl's Nest.
It's less about, as I said before, it's about the effects on openness, the physical effects on openness.
I'm not asking you answering questions. I'm not asking you. I was just trying to matter. I thought it was very simple because I thought it was an agreed matter. But you raised queries about, but we can agree. Pembury Hospital. Right. Okay. So in terms then of zone of visual influence, do you consider that to be relevant or irrelevant to the inspector's assessment of visual impact on the openness of the green belt?
I feel it's relevant, but in a number of ways, and I think it's relevant in terms of both the open views of the site and how the site would be perceived itself. So yes, if visibility is part of greenbelt assessment, but there's nothing in greenbelt assessment that talks about distance. And I think if we could draw the inspector's attention to CD 0609, which is an appeal decision. It's page 5, so it's paragraphs 21 and 22 in particular that I would like you to be cognizant of. Paragraph 22 states that the development would not impact on the openness of the greenbelt beyond the site itself due to the level of containment. Moreover, due to the removal of the care home, etc., etc. Nevertheless, the development will result in harm to the spatial and visual openness of the greenbelt that would be permanent with a greater degree of activity generated than existing. So I believe that in terms of visibility, it's not just views from the Pembury Road and from Pembury. I believe in terms of openness, it's pertinent to talk about the visibility from.
Now, of course, that is a factor as well. But you say that there's nothing about countryside, but of course, and we've been to. We just go back very quickly, and then we look on encroachment. But if we look, we started earlier, didn't we? When we look, when we're looking at the impact, for example, in the Greenbelt study, we're looking at the impact, isn't it, of the development in the wider countryside as well, aren't we?
Please could you take me to the parts of the Greenbelt study that you were looking at? I believe the short answer is yes, they're interlinked. You're looking at it first and foremost, is the site part of the countryside established? Yes. And then you look at the wider links to the countryside, which I believe are there.
Because in your oral answers, you equivocated from talking about the countryside, and then once you did then qualify and say the wider countryside. So we were looking at before, we don't need to go back to it unless you want to, and I'll take you to some other places. But the passage, just to be fair, that I was referring you to at the beginning of the cross-examination, was CD 523, Council Stage 3 Assessment, para 3.6, which talks about the wider countryside we looked at, and and in terms of looking at the impact of any development, in terms of the distance is a material factor, isn't it? And I think you say that at that's at core document 523, 3.6 of the council's stage 3 assessment, isn't it? The assessment of harm is considered cumulative out from the inset settlements, i.e. an extension. We're on page 14.
And paragraph
3.6. It's above 3.7 that I just took you to. It's which relates to the wider countryside that we looked at the beginning. It's a sentence, last sentence, 3.6. This context in the assessment of harm will typically increase with distance from settlement edges.
correct. And in my proof, I've set out the distance from the development to the settlement edge at paragraph. It's not the proof, sorry, it's in my appendix. So CD 08.11.02. And I've set out at paragraph 5.3.5 on page 15, the distance of the proposed development from the edges of the existing limits of the built development to the west.
Yes, okay. So let's quickly then finish off, go through quickly the purposes. So we start purpose A, check unrestricted sprawl of large built up areas. Can you just help me with the use of the word unrestricted and sprawl? Can I suggest to you that having regard to whether there would be good defensible boundaries is relevant to whether development is unrestricted and sprawling?
Yes, sir. I believe that defensible boundaries are relevant. In this case, we've got a moderate boundary which defends the existing greenbelt extent, and that the appeal site breaches that.
No, but we're going to look at what impact this proposal, I'm focusing on this proposal now, and you test it. So against the purposes of green belt, yes?
Correct, that's what I was doing.
Yeah, no, not changing green belt in an examination in public, but when we're looking at a development that is, by definition, we're going to be looking at inappropriate development, or we wouldn't be here, would we? Regardless, and inappropriate development nonetheless has a spatial and visual impact. Appropriate development has a visual and spatial impact, but that's another case, another time. But to check unrestricted sprawl of large built-up areas, can I suggest to you that it's relevant in carrying out that assessment, and indeed highly relevant, to see whether or not the proposal would give defensible barriers, because that's what's meant by unrestricted and sprawl.
And this relates to paragraph 3. You're saying that the boundaries, the question is that the boundary is the only consideration with regards to unrestricted sprawl, or are you saying that it's an important consideration?
I'm suggesting one, it's a consideration, and secondly, it's an important consideration, because it doesn't say just to check inappropriate development outside of large built-up areas. It says to check unrestricted sprawl. It must mean something. Unrestricted sprawl.
Correct. To my mind, the green belt is there to stop, after looking at inappropriate development and the extension of settlement into the green belt, and that if you're looking at the specific case of the appeal site is located beyond the furthest extent of Sandown Park. So in terms of you're extending Tunbridge Wells out, sprawl, and that it is unrestricted because you cannot change the green belt boundary.
So in that, I'm suggesting you've got to apply each of these purposes and to see how a development scores against it. And so you say unrestricted sprawl doesn't really have any sort of particular meaning at all. Because you just say if you're outside the green belt and you're in appropriate development, you are unrestricted sprawl.
So I think in the particular case of the appeal site, I believe it is unrestricted sprawl to a moderate degree. And I think I put that in my evidence at page.
It's not quite the question I'm putting to you. I'm putting to you, which is the question I put.
I follow it
so I put to you, is it relevant and greatly relevant? Let's say it relevant to the inspector. I know you don't agree with the outcome, but can we agree that whether or not you've got defensible boundaries of the site is a material consideration when judging it against whether or not it is unrestricted sprawl and to what extent it harms that purpose? Do you agree or not?
I agree that it's relationship with the rest of the green belt. So in terms of, for example, we're getting to.
Can you just answer the question, please? I don't actually care now whether it's yes or no. I just need to know. Is it material, your advice to the inspector, whether in assessing how much harm this does to the purpose of purpose A, is it relevant or irrelevant? And purpose A, we only got to purpose A at the moment, unrestricted sprawl, whether or not the site has defensible boundaries, is close or not close to the urban area. So let's just stay with strong boundaries. Is it relevant or irrelevant? I don't mind which, I just need to know your answer.
I think for the purposes of this, it's not relevant.
Okay, fine, and that's the approach you've taken. Good. Okay, B, wants to turn to prevent neighbouring towns from merging. Now, even if we assume Pembury is a town, can we agree this, that the purpose B is in relation to neighbouring towns merging, not coalescence with built development elsewhere? This is a separate purpose that is focused simply on neighbouring towns from merging. Yes?
No, as in coalescence elsewhere, not within the vicinity of the gap between the two towns, or coalescence elsewhere, as in, if you could clarify, please.
Yes, your case now, as you said, is now a relationship between the appeal site and Pembury Hospital, which is not part of any town or village even.
But both are within the gap between Tunbridge Wells and Pembury.
So isn't the thing that we need to be focusing on
Looking at the green belt purpose is to prevent neighbouring towns merging and the contribution of a set parcel of land to prevention of neighbouring towns merging. My point is, and I've set it out in the table at page 13, is that the open space to the west of the A21 is that contributes highly to preventing neighbouring towns.
But Pembury Hospital is not part of a neighbouring town.
And it isn't, as we've
And
already covered, it is part of the gap between neighbouring towns, and as we've covered, it's inappropriate development in the green. It's not inappropriate, it's material, it has a material effect on the green belt.
And can we also agree this? It's not between Pembury and the appeal site.
So, yes, but that's not what we're measuring. We're measuring the separation between Pembury and Tunbridge Wells. And if you extend Tunbridge Wells physically to the hospital, then there's a narrower gap between Tunbridge Wells and Pembury.
I'm struggling with this when we agree that Pembury Hospital is not part of Pembury, correct?
Correct, it's part of the gap between Tunbridge Wells and Pembury.
And it's not part of the gap between this site within Tunbridge Wells and Pembury, is it?
It's not, yes, it is part of the gap between this site and Tunbridge Wells and Pembury. It is not the shortest distance between this site and Pembury as it stands.
Well, if you were to look and see, we can agree this, that you look and see the site and you see where Pembury is, the hospital is not in between the site and Pembury, is it?
Again, no, not as the crow flies, but
Well, not as anyone.
both
Okay.
the site and the hospital are between Tunbridge Wells and Pembury. Cumulatively.
There are lots of places that are between Tunbridge Wells and Pembury, but then you don't then elevate that into effectively you've treated, and this is why it wasn't very clear in your evidence until the inspector's questioning. Problem is you've treated Pembury Hospital as if it is part of Pembury.
No, I disagree. I've treated Pembury Hospital as built development within the Greenbelt in association with the garden centre and the hotel and soon to be Al's Nestos. And my opinion is that that development to the northeast of the A21 is impacting on the openness of the Greenbelt and is impacting on the edge of Pembury, and that the site in its open land use currently in Greenbelt terms is a key part of the prevention of neighbouring towns merging.
And in terms of, do you agree that in terms for that purpose, the visual intervisibility is a material consideration or not?
Yes, I agree, but to a lesser extent. And I think I've set that out in my evidence.
Well, you've clarified what you mean by indivisibility, but I just wanted to, not going to debate with you the weight to be put on it. Purpose C, to assist, because I'm an iron, assist on safeguarding countryside from encroachment. Now, could I just ask you about this? Can we agree that one has to assess the harm to the green belt against this purpose of any particular application that's inappropriate in the green belt? Yeah, and so we have to see to what extent it would harm assisting in safeguarding countryside from encroachment. And that will be, that can range, can't it? From whatever range up to high, from negligible or little or whatever. It's a relative range, isn't it? depending on the particular.
Yes, I refer to the range set out within the stage 2
Right.
green belt assessment produced by LUC.
So in looking at that, simply because it's inappropriate development and simply because therefore it will have a spatial and visual element, there's more to that when you're assessing, isn't it, whether it can safeguard countryside from encroachment. And can I put some points to you and see if you can agree that they're relevant or not? Is it relevant, for example, to see how the site relates to the wider countryside?
Yes, I believe I've done that in my assessment.
Yeah. And that's a factor that has a high degree of importance, because for this purpose, it's about safeguarding countryside from encroachment, isn't it? You're looking at the countryside rather than just a site.
Can you clarify? So you're asking me, you said just then that it's got more importance.
Yes.
But then you went on to say that its importance is about stopping the spread further into countryside. I agree with the latter part of that, because I think the development of the site and the openness of the site to the southwest risks the encroachment further into the countryside to the south, but that I disagree with the first part.
Right, well, let's take it in stages then. First of all, if you've got a site that is prominent and open visually in the countryside and has a strong influence on the wider countryside, then inappropriate development is likely to cause more harm to this purpose, isn't it?
No, not necessarily, because I think there's a lot of, and I'd like to take you back to the evidence that I've talked about earlier, in that there's an overlap in your question regarding landscape and visual and greenbelt. And in greenbelt terms, it's your experience of openness in the views that is important. So while I agree that there would be effects on the countryside in views experienced from Sandown Park, the unmade track, I don't agree that if the site is widely visible, that means it is encroaching into the countryside more. That doesn't go back to greenbelt policy, and it's not reflected in the methodology for the stage.
Okay, you don't agree that. Do you agree that urbanising influences are relevant?
Yes, I think that there are very few, if any, urbanising influences pertaining to the appeal site.
And well, there's obviously disagreement. The inspector will deal with that, but that's agreed, and as a matter to take into account. And in terms of its relationship, then with it is located, isn't it, between whatever the suburban, rural fringe, suburban area of Sandown Park and the A21, isn't it?
It's located, yes, between those two elements, and it's also located adjacent to the rural woodland to the north and the rural landscape to the south.
And do you take into account, do you say the inspector should take into account all of those features, or just the woodland?
Yes, no, I say on page 13 that it is agreed that the appeal site has a degree of separation from settlement. However, if looked in isolation, the appeal site has appreciable links to countryside to the north and south. Then I've looked at the assessment analysis extract from the greenbelt purpose of the stage 2. The parcel has a degree of separation from both the settlement and the wider countryside with relation to the methodology that I've employed. And I agree that there's a moderate contribution which applies equally to the proposed development.
And insofar as last week, where I think we achieved agreement that the area of landscape, when we were looking at landscape, was about 500 metres around the site. Is that a context which you would agree would be relevant in looking at assessing whether or not this site has urbanising features within that, or its impact on encroachment on the countryside. That 500-metre area, is that something the inspector can see is broadly consistent for those two topics? I know they're different but overlapping, but I just want to help the inspector.
So you're looking at the wider links to the countryside.
In terms of encroachment, I'm just on this purpose.
On the appeal side, which you inferred was the same. I don't think that the wider 500 metre or whatever is relevant to the urban influence on the appeal site. I think, and I hope the inspector has seen from his site visit yesterday, can make up his own mind, the urban influence exerted on the appeal site itself, and on the connection of the appeal site to the wider countryside.
I was just asking to see if there's broad agreement on the area around which the inspector should be taking into account for the purpose C, safeguard countryside from encroachment, when looking at, you've agreed, relevant factors, urbanising factors, whether it's copses, whether it's woods, looking in a roughly 500-metre area, or you're saying no, you take a completely different approach. That's all. I mean,
no, I've looked at it with regards to the methodology set out in stage 2, and I've applied that methodology.
I'm talking about the distance of what you're looking at. Are you disagreeing with your? No,
I don't think that looking at specific distance is relevant. I think you need to look at the methodology and the way in which the Greenbelt contribution to the countryside has been assessed, to take a view. And that, you know, if we go again to, we've looked at this earlier, and I can take the inspector to it again, but there are lots of places where it says that it's the harm to the site and then to the wider countryside that is important. So to my mind, we're looking at the appeal site primarily,
yeah,
and as a secondary access assessment, we're looking at the wider countryside. And to my mind, the site is connected to the north and to the south to the wider countryside. And at the moment, there's no stopping of that. There's no ending to that connection.
So I'm just looking at purpose C to assist in safeguarding countryside from encroachment. Are you suggesting a two-tier weighted system, that the site carries the impact of development on the site carries more weight than the impact on the wider countryside? Or don't you just assess it as a whole? You look at the countryside and assess it as a whole.
I'd like to, if you bear with me a moment, I would like to go to the methodology that was used.
You deal with it at 5.2.3 in your third table.
Yes, and I've agreed that the parcel has a degree of separation from both the settlement and the wider countryside.
So I was just saying, the wider countryside, are we looking at the sort of 500-metre area or not? Just,
I didn't have a specific area in mind, but you can.
so you see the wider landscape is, the wider countryside is different to the surrounding landscape.
Pardon? What?
Wider countryside in around this site, is it a different area to the surrounding landscape that we were looking at last time? Yeah, different size, different space. Are we looking? What's the inspector got to look at? What do you say?
I don't understand. What I want the inspector to look at is the methodology employed and how we've assessed it. And I'm in general agreement with the assessment that was carried out by LUC with regards to the contribution to the countryside.
So
I don't understand the relevance of.
Well, you must have an idea of
where the countryside is.
You must have an idea of what countryside you were looking at.
Greenbelt terms is all of the open land within the Greenbelt.
So it's a whole. It's its impact on the. Okay, it's the impact then on the whole of the countryside that's in the
Impact on the site, and it's the impact on its influence on countryside. And
and the countryside is the whole
in
countryside.
terms of its
Mhm.
influence, it would be a gradation, wouldn't it, from where you affect it to. I just don't understand what your question is. Yes, sir, please
Just to
do.
help me. We're talking about purpose C.
Mm.
You're, Mr. Jones, you're trying to understand what
Encroachment.
means by what she's referring, what she would refer to as countryside.
Yeah, that's being
in terms of
encroached.
it's being encroached.
Yeah.
Yes, I think Mr. Jones is suggesting a roughly, I think his words,
Yeah.
500-metre area, and he just wanted to know whether that you would concur with that or not.
Thank you, sir. I think I don't agree that it's relevant, so I think that the purpose is to assist in safeguarding countryside. So if you're safeguarding the countryside from encroachment, the purpose is to keep the land open so that there is no encroachment into the countryside. I think so the contribution is about protecting the countryside from encroachment. You could put a distance on it or not. It's the physical, it's what the site is doing to protect encroachment into the countryside.
I kind of thought that was your approach from your answers in chief, which are literally different to the answer you gave in crossing. There's no graduation. As far as you're concerned, any inappropriate development encroaches into the countryside by definition because you built something that's inappropriate. End of.
Yes,
Yeah.
that's the first part.
But that's not the right approach, isn't it, when you're trying to assess against the purposes? By definition, inappropriate development is harmful to the green belt because that's how the policy sets it against those purposes. So when you're looking at assessing the degree of harm, there's got to be a graduation in all of these purposes, not the absolute.
On page 13, I've said the degree of harm is moderate. And I've explained that I've followed the methodology set out within the stage 2 greenbelt assessment.
Why is it moderate? Why is it anything else? It's got to be a case, isn't it? When you're looking at, if you're assessing moderate or whatever level, you need to identify what is the countryside that it's encroaching to, and where is it from? How does it relate to other urbanising areas? How far are you going to go? How far are you going to look? You've got to identify, I would suggest, respectfully, some area of land that's being encroached.
And I'm saying that the appeal site has links to the countryside to the north and south, and therefore it would be those elements that would be encroaching.
Okay, for no particular distance.
There's no distance
Okay.
out in the stage 2 study. It's not part of the methodology.
Okay, so we can move from this. I think we can do purpose D. We're in agreement. Relatively weak contribution. Yes.
Correct.
Good. And then let's see if we've got any. Okay. Yeah, it's just. Okay. Bear with 1 moment. No, I think we've been through that, and that's fine. Thank you very much, sir. Thank you very much, Miss. Sorry, it's a bit longer, but my best.
Thank you very much.
I've got about three things, I think. I think we could do it quite shortly.
Do it. do it then, have lunch.
Yes, I think
Yeah.
that'd be better. Is that okay? So is everybody, Mrs. Kirk, are you okay? Just
Just
a few more things. I know the tummy's rumbling.
You.
Thank you. You were asked whether you would accept that development of the site would cause less harm to spatial and visual openness of the green belt than the development of the whole of TW5. Do you remember that?
Yes.
And you said there are caveats, and you wanted to explore the caveats, but you didn't get there. What were the caveats?
I think that within certain areas of parcel TW5, there are elements of it, for example, with regards to urban sprawl and my differentiation in the contribution of the site to urban sprawl and the measured one for the parcel, is that much of the parcel is, just particularly to the southwest, is contained by settlement on more than one side and the road to the south. So there are elements of looking at the Greenbelt study with regards to the site in isolation, where the site has a higher contribution to the purposes than that of the parcel TW5.
It's part of the parcel.
Lot of questions about boundaries, and on the eastern boundary, let me just turn up TW5 plan. TW5 plan is 052205. And you were looking at the eastern boundary there and the A21, and you agreed that the A21 would be if it was relevant, that the A21 would be a strong boundary, and you said yes in terms. How strong is the A21 boundary if Owl's Nest is developed?
In terms of that's where my point about the stage 1 assessment that I took the inspector to, and the idea that if there's settlement on both sides of the A21, then the strength of the boundary is diminished. So with regards to the Owl's Nest being in such close proximity to the proposed development site, such as identified on HGA 5, that there is the possibility, should you be looking at greenbelt boundaries, that the boundary of at that point would be weakened.
Thank you. And so, and for the inspector's note, a good place to look at where you see Owl's Nest being developed and its relationship to the appeal site is in your plan 5 in CD 081103. That's the plan that you just referred to.
Yes.
Thank you.
Can I just, do you mind if I just clarify?
No, of course, sir.
And Ms. Lambert, feel free to come back in.
Thank you.
So you're saying that the Owl's Nest development would weaken the strength of the A21 as the eastern boundary.
So I'm saying that, and again, this goes back to our prolonged debate about boundaries, but I'm saying that should you wish to consider the A21 as a greenbelt boundary, then the fact that there's development on both sides of the A21 could have a weakening effect on the strength of that boundary, because you've got, it would be as in other places along the A21, where in the stage 1 assessment, if there's settlement on both sides of the A21, then it's not perceived as a boundary, because it's not an edge. And to my mind, what the council have done in both of their assessments is think of the A21 as the defining edge in greenbelt terms of allocations at Pembroke, but that it's not sufficient. If you use it as a boundary for both sides, then you haven't taken into consideration the cumulative effects, because the assessment looks at sites individually. If both if TW5 and PE4, to look at the plan that Emily's just referenced, were developed, the A21 would be the only separation between the two. And to my mind, that's insufficient, and that the stage 2 assessment has alluded to that by virtue of saying that although it is a strong boundary, the open land within the parcel TW5 is important. Does that make sense?
Ms. Hunt, I was only seeking, thank you, Ms. Kirk, I was only seeking clarification of just what I heard, and make sure that I noted that down correctly.
Yeah, thank you.
I did note it down correctly. So thank you, Ms. Hunt.
Good, thank you, sir. You looked with Malone and friends at the southern boundary. You looked at all the boundaries of the appeal site. And in relation to the southern boundary, it was broken up into sections with you. And you had a discussion about the southwestern section as well. Can you help, please, as to your overall opinion of the strength of the southern boundary, if it's relevant to the appeal site?
So if you look at, and I'm just going to go back to, I can find it, where they.
I'm looking at your plan in Appendix 3, Plan 2.
I wanted to go back to the methodology for what the boundaries, what constituted a strong, moderate and weak boundary, or what the terminology was in the appendix for.
That's stage 3.
Yeah.
So it's CD 0523.
Page number again.
Sorry. Oh, sorry.
You have it, sorry. So it would be moderate to low, but I wanted to check the terminology. I don't know if low is the appropriate term that they use, but it would be moderate to the southeast and low to the southwest. If that's the, can anybody find that for me? Sorry. Page 19. Page 19. Thank you. Thank you. Is that stage 3? Oh yeah, it's I'm looking at the TV pages. Oh, sorry, there, weak, sorry. Moderate to the southeast and weak to the southwest.
Thank you.
Sorry about the delay there, sir.
And given that you've assessed it as part of it as weak, what do you say about how defensible a boundary it is, if that was relevant?
If it was relevant, it would be less defensible than the existing greenbelt boundary, which is moderate, strong.
Thank you very much, Mrs. Kirk. Those are my questions. Thank you, sir.
Thank you very much, Mrs. Kirk.
Thank you.
Thank you. should we resume at 2:15? Would that be 50 minutes? Do you want to, is that too long, not long? Plus now?
It's okay. Thank you, sir. 50 minutes, yeah.
50 minutes.
Mr. Gibbons, I just wanted to check, are you happy with this setup? I'm conscious that I have the Rule 6 party behind me, which from my perspective is acceptable, but are you? I didn't know whether.
They're not going to do anything violent to Mr. Gibbons.
I can assure you that they've not been pulling faces.
I was given the same opportunity to be in a different location, and I was happy with this location, but I think you should have the same.
I've heard you, Mr. Kirkman.
Okay.
I've not spoken to you at all. Maybe there were some people behind you couldn't hear early on. I hope they've heard you a bit more now. And I would suggest that since we've had this format to present your evidence, that we have the same for Mr. Gibbons this afternoon. And it's been acceptable from my point of view. Mr. Kirk, thank you very much. It's been a long morning into the afternoon for you, and I know again we've kept you from your lunch.
I know.
Life of an expert
And I'm grateful
witness.
to the applicant for keeping us on time. Thank you. So we'll resume at 2:15. Can we start? Just two things I just want to raise. One is the attendance list of referred to. Great, thank you. Excellent. And secondly, this James wants to just make a comment about the or give some advice about the toilets and things that because of courts and operation.
So the court is in operation in the council chamber at the moment. As far as I was aware, there was nobody turned up to the session this morning. They are in for at least 2 hours this afternoon. So we just need to make sure if we're leaving, please be quiet. We're not allowed to use the toilets which are in the female robing room. So if female people would like to use either disabled toilet or there are staff toilets through the corridor for male and female, there's easily accessible male toilets on this corridor here. If you need a pass, there is a pass left at the end of that table. Thank you. And that's just for today. We'll be in the council chamber tomorrow.
And the rest of the week?
For the rest of the week, we'll be in the council chamber and we should be able to use it to access and move our belongings in there this afternoon.
Oh, fantastic. Thank you. No, that's great. Thank you very much.
Thank you very much. Mr. Jones.
Thank you very much. Can I introduce to you, sir, in the flesh this time, Mr. Gibbons, who's seated there. Sir, you should have proof of evidence from him, a summary. Don't worry, I'm not going to read out the summary, it's rather long. And exhibits. And what I propose to do is introduce Mr. Gibbons and then just take him through, I hope, topics that you will find useful which are sort of explored a little bit with Mrs. Kirk that are at issue. So, Mr. Gibbons, you take up your proof of evidence, you've set out your qualifications, experience and scope. Can I just ask you to read, just so you get used to volume, paragraph 2.1, and then I'll ask you to confirm your statement of truth with 11.1 of your proof.
My name is Mark Gibbons, and I'm a director of Indigo Landscape Architects Limited, a landscape architectural consultancy based in Salisbury, Wiltshire. I hold a Bachelor of Arts Honours degree in Landscape Architecture. I'm a chartered member of the Landscape Institute and have been a practicing landscape architect since 1992.
Thank you very much, Mr. Gibbons. And could you just confirm your statement of truth, which you've signed at the end of your proof, insofar as it applies to your proof, your rebuttal, and your and the evidence you're giving to this inquiry?
Yeah, I confirm that statement of truth. Would you like to read it?
Yeah, just read it, and then we'll get on to substantive matters. I think I can hear you well enough. I hope others can hear, Mr. Gibbons.
I confirm that I have made clear which facts and matters of this in this report are within my own knowledge, which are not. Those that are within my knowledge I confirm to be true. The opinions that I expressed represent my true and complete professional opinions on the matters to which they refer.
Okay, thank you much, Mr. Gibbons. I'm going to take some of the topics that we dealt with Mrs. Kirk broadly in the same order, but not entirely, so that will help. So if we deal in the order, just a discrete issue first of all, can you, TW5 and the appeals site, I think there was agreement that it, in terms of size, it was relatively small. Can you please just deal with the issue as to whether or not, and we heard in re-examination, I think Mrs. Kirk say, as a caveat, it was conceivable that the development of the whole of TW5 could have a greater impact on, I think, the openness of the green belt than just the appeals site. Can I have your comments on that? Is that something you understand?
I disagree with those comments. I don't think that releasing the whole of TW5 and putting development on it would have a greater effect, impact on the green belt than the Bill site, which is plainly quite a lot smaller.
And when we then go to look at the assessment that's being carried out, the green belt study, that was, I took Mrs. Kirk to that. Next, you might just have it to hand, CD 522.
That's the stage 2 assessment.
Stage 2 assessment. But before we go there, can we just look at the stage 3 assessment? Another paragraph went to a paragraph 3.7, 5, core document 5.23. Tell me when you've got that.
I do.
And you'll recall, to Mrs. Kirk, in the connection with those questions, the release of larger areas clearly has more potential to weaken the integrity of the green belt by extending into land that has a greater distinction from urban edges by diminishing settlement separation, diminishing the extent which remaining open land relates to the wider countryside. First of all, could I, as a broad proposition, your views on what's said there in that extract from the Council's Green Belt study?
I think it's fairly plain, isn't it? The release of a larger area clearly has greater potential. I think that first statement there sort of sums it up, really. And that's the proposition you put to me with regard to the release of whole of TW5 just now.
And could I just also then, thank you, could I also ask you about this? Why are they concerned? We see diminishing settlement separation, diminishing the extent to which remaining open land relates to the wider countryside. Can you help me, and the inspector, please, why in the assessment there is a concern by the wider countryside? What do you understand it to be?
Because assessing harm that would occur as a result of the proposal, clearly it's highly relevant whether that harm will be extremely localised or just the site itself, or whether that harm will spread into adjacent areas.
And is that relevant or irrelevant to the level of harm in terms of both spatial and visual to the green belt?
It's highly relevant.
Thank you. Could I then ask you now to go to stage 3, 52205, under the heading again is a point I put, relationship between settlement and countryside. And it's a passage that deals with the parcel forms part of a major part of the narrow gap. It's the A264 point.
Could you give me that reference again?
Yes, I'm sorry. It's core document 5.22.05.
Sorry.
And
yeah, I got that.
so it's the passage, the parcel forms part of a major part of the narrow gap between Tunbridge Wells and Pembury. The A21 and its containing tree cover, which prevents any indivisibility between the two settlements, is a key element in settlement separation. And then it finishes with talking about the small size of the gap and the connection provided by the A264 means that the open space within the parcel also makes an important contribution. Settlement gap. So I just want to ask you a couple of points, which put to Mrs. Kirksey, so the inspector knows your respective positions. In terms of what they say, first of all, the A20, the gap as identified is between Tunbridge Wells and Pembury, is that correct?
Yes.
And the A21 and tree cover prevents any visibility between the two settlements. And I think that's now agreed by Mrs. Kirk. What's your position on that? I think you said it out.
I agree. prevents any, there's no intervisibility between Pembury and the appeal site at all.
Now, they say that's a key element in settlement separation, the lack of interdivisibility between the two settlements. Can I just have your comments whether you agree with them that it's a key element? Because that seems to be the issue about indivisibility and visual visibility is clearly an issue between Mrs. Kirk and yourself. But here they say it's a key element in settlement separation. What do you say?
This obviously was referring to the whole of TW5. We're looking at the appeal site, but 100% is a key element. The strength of the boundary and the vegetation in creating that settlement separation is essential.
So moving then on to the second part of that, having had the key element of indivisibility, but they then says the small size of the gap and the connection provided by the A64 mean that the open space within the parcel also makes an important contribution to the settlement gap. Now, just pausing there, I don't know where's the best, whether it's Mrs. Kirk or whether you have a plan or a photograph, just so that I just wonder if we could have where's best up, whether it's HA5 or what have you, to just look and see what.
I would suggest the agreed zone of visual influence plan is a useful one.
Okay, ZVI.
The ZVI plan. I've left mine. Look at that. Sorry, there's a folder open over there. Apologies.
There's also
Excuse me,
another.
my folder. I'm just going to grab another folder. The stuff I had yesterday, which got wet on site, had the CD numbers on it.
One of them, I think, one round, which is something I want.
Yeah.
So it's yes, so it's CDO 7110202.
Yeah, I got my wet version from yesterday.
Oh, right, okay.
Try it out now.
So did mine, the edges all crinkly along the top.
Okay. Now, I always, this is only a matter of time before this is being knocked over. Never get through an inquiry without knocking over the papers. But if we just have a look at the plan, the reason I just, sorry to pause there, is I just want to look and understand as best we can. Obviously, none of us here were the authors of the assessment, but first of all, where it's talking about but the small size of the gap and the connection provided by the A264 means that the open space within the parcel also makes important contribution to the settlement gap. So the settlement gap, as we know, is that between Tunbridge Wells and Pembury. And the A24 is the Pembury Road, yes, running sort of southeast or northwest, depending which way you're going. Yes,
Correct.
So just help me, and again, the inspector will read it and take his own view. When talking about the small size of the gap and the connection provided by the A264, mean the open space within the parcel also makes an important contribution to the settlement gap. Help me with this. You said, so you said it's the fields to the west of Pembury, but they have particularly in mind. Could it be in this context, if you look up on the west side of the A21 and the Tunbridge Wells Hospital, as it's actually called, and looking across there, so that, do you see what I mean? We'll come on to
think
debate that gap in that issue in a moment, which I.
No, I don't think that the Tunbridge Wells or the Pembury Hospital, whichever it's called, influences the connection. You know, it says in there, but the small size of the gap and the connection provided by the A264. I don't think the Pembury Hospital has got anything to do with what they're talking about there. They're talking about the fields that are immediately on the north side or the northwest side of the Pembury Road.
Are they talking about your opinion as to whether it's plausible that they're meaning the Peel site or the whole of TW5 in this context?
They've not been specific, but so for your note, 7.3.10 of my proof of evidence, point 2, I cover my opinion on this, which is that there is very little visibility. There's only, as you know from our discussions the other day and on site yesterday, my opinion is that there's only the barest glimpse in winter of any potential view of the site, of the appeal site proposals. And I think when they're talking about this, you cannot see from the Pembury Road, you cannot see the appeal site. And I think that this quote is referring to the fields that are close to the Pembury Road, which clearly when one is on the Pembury Road, driving, for instance, if you're heading out of Tunbridge Wells towards Pembury, they're on your left. It's those fields that are key to the connection that's provided by the Pembury Road. That's what they mean by that. Okay. Our site is not form part of that.
So I then want to take you, if I may, then please, to, because I think it was in Mrs. Kirk's rebuttal that she said she had carried out a stage 3 as best she could.
Can I just stop you 1 second, plug my computer in?
Oh yes, of course.
That's better. Sorry.
So I think right, and the inspector will see, it was in Mrs. Kirk's rebuttal that she said, she explained, or her methodology was to then go on and explained her methodology in greater detail.
Mrs. Kirk didn't do a rebuttal on Greenbelt elements, so I think it must have been in her Greenbelt.
Oh, sorry, Greenbelt review.
Greenbelt appendices, appendix 2.
My apologies. So I just want to deal then with Greenbelt assessment, just some headline points for the inspector's assistance as to where there are issues. So first of all, is there a defined approach to Greenbelt assessment?
Sadly not. No, there's no standard national agreed approach to Greenbelt assessment. It's something that the Landscape Institute are pushing for, but I don't know if sadly there's been any progress on that. But there isn't one currently.
Okay, so Mrs. Kirk, just for your notes, I think it's 1.1.4 of her proof says, as we know, she says what she's done is she's adapted the council's methodologies for site-specific purposes.
That's, I believe,
what she says. And one of the we've seen, and we spent some time on it. We're going to spend a little bit more time on it, but hopefully not as much. At page 11, para 512, she says boundaries and release from Greenbelt are not relevant to her assessment. And I think so, it's not in dispute, but fourth bullet point under 5.2.1, specifically in relation to boundaries.
So yes, we're now in the previous quote you gave was from her proof, and now we're in her
Greenbelt assessment. Apologies if I haven't said that. Greenbelt 11.512. So can I just have, please, for the inspectors, note what you say about whether what Mrs. Kirk has done has been a correct adaptation of the council's Greenbelt assessment, assuming, of course, which is a matter of much debate at the EIP as to whether the council's Greenbelt assessment was correct or not, but that's a matter So one of your colleagues is grappling with.
As I understand it, Mrs. Kirk, has undertaken, she says, the stage 3 Greenbelt assessment, but then she has said consideration of boundaries and impacts on release of Greenbelt are not relevant. The stage 3 Greenbelt assessment is different from the stage 2 Greenbelt assessment. The stage 2 Greenbelt assessment considers the effects on the site and the contribution of the site, and considers boundaries as part of that conversation. The stage 3, and that's demonstrated in many respects by the comment that you referred me to earlier in the TW5 assessment, where we talked about, the A21 and it's containing tree cover prevents it. That's a boundary that we're talking about. So the stage 2 assessment considers the boundaries as a part of the assessment process. The stage 3 assessment, and you have to forgive me here because it's now moves into steps. The stage 3 assessment is a 3-step process. The first step of which Mrs. Kirk appears to have done, is a focused look at the site, and in doing so looks at the boundary that is adjacent to the inset development. So it's a focused look at the site, but not taking into account at the step 1 the outer boundaries. Excuse me. Step 2 of the stage 3 study then considers the effects. And I'm just going to put it up here so I quote it correctly. It says the impact on release of adjacent greenbelt. And in doing so, it picks up, that's where it considers the outer boundaries, the outer boundaries of the site, because obviously they sit between a site that may maybe be about to be released or whatever, and those adjacent areas. So boundaries are considered in that process in step 2. And then the third step of the stage 3 process is to bring those things together. So you look at the effect purely on the site, then the effect on the surrounding areas, and as partly because of that, how the boundaries play into those effects, and then you make an overall judgment. There's some examples of how you get to your overall judgments. So in either process, boundaries are integral to it. They're absolutely integral to the process of understanding the harm to the greenbelt. And by omitting the boundaries from the process, with taking you back to Ms. Kirk's page 11 of her Greenbelt assessment on paragraph 512, she's effectively losing that middle step. So she's effectively assessing the effects on the site, and this kind of goes with what Ms. Kirk was saying earlier, I suppose, but not assessing the effects on the boundaries of the surrounding areas and as a consequence of the boundaries.
Now, what she says is, well, look, the council there were looking, and their consultants were looking as part of the EIP, as part of the development plan, and looking for release of land from Greenbelt. Release necessarily means if you release it, you're going to have new Greenbelt boundaries, whereas here, I think it was agreed that the inspector is assessing the level or degree of harm to openness, judged, amongst other things, by reference to the purposes of including land within the green belt. And so she says, well, boundaries are not relevant in that sense, green belt boundaries, and whether the sites would have, any site would have a strong, moderate or weak boundary, because it's not going to be a new green belt boundary. I think that's being, yes. So,
my answer to that hopefully is fairly short, is in that what both are doing is assessing harm, and whether one was to release land from the green belt, part of the process is assessing harm that would occur, and whether one was to look at development on the site, even if it isn't released, we're still looking at the harm that would occur to the green belt as a consequence. So they're doing the same thing, albeit we're not, as you rightly said, proposing to release the land from the green belt. They're assessing harm.
So just, we'll come on to the purposes of including land in the green belt. but can I just put it to you, first of all, in general terms? In terms of your advice to the inspector, when we come on to the purposes of the including land within the green belt, if a particular site has, let's say, strong boundaries and one has weak boundaries, is that relevant or irrelevant to assessments as to the level of harm that might be done to the openness of the green belt?
It's highly relevant because obviously a strong boundary will reduce any potential harm to surrounding green belt as a consequence of the strength of that boundary. That's made plain in the TW5 text of TW5 as well.
Even though the official green belt boundary is not to be changed.
In terms of looking at harm,
yes.
In terms of looking at harm, it's highly relevant. Boundaries are relevant throughout. You can't ignore the boundary.
So if we then just turn then to looking at your judgment and Mrs. Kirk's judgment on the purposes of including land within the green belt in respect of this application, we start with purpose A, and you may want to have your proof of evidence to hand. You? Okay, so should we start with purpose A to check unrestricted sprawl? And can I ask you first of all, in relation, your understanding to that, in relation to checking unrestricted sprawl, to what extent, if at all, would the boundaries of the site be capable of being relevant, if at all?
Well, they're highly relevant because if the appeal site was to be developed, the strength of the boundaries around the appeal site have a significant impact on whether the further unrestricted sprawl would occur. In this case, we've got very strong boundaries to the north and to the east, and a varied boundary to the south. I think I set that out in my rebuttal. And it's highly relevant. It's a very contained site, so it becomes highly relevant in terms of restricting further unrestricted sprawl.
Just pausing there, could I take you to 7.6.6 of your proof?
Yeah.
Just setting out make submissions on in due course, but your understanding, phrase check unrestricted sprawl is often taken to mean that no development should be allowed within the green belt. However, there is nothing in the NPPF paragraph 13A to say that some development is not acceptable. You go on to deal with very special circumstances. But what is the, what do you understand the terms unrestricted and sprawl to connote in terms of harm to the green belt?
Sprawl is talking about urban sprawl, clearly. Unrestricted means endlessly, I suppose. And as I've said in 767 in my proof, there are exceptions, and obviously very special circumstances can provide an exception.
In terms of that principle, just for the inspector's note, you will have seen it, you refer to the green belt assessment at 768 and the PAS advisory note.
Yeah.
So in terms of this site, then, I mean, you set out, what do you say, and the inspector's now been on the site visit, is factors that that you would draw to the inspector's attention. Now, Mrs. Kirk covers this in 5.2.3 of her Greenbelt assessment. Can I just ask you to comment, please?
Yes, I mean, essentially there's this site is very, very well contained by the surrounding road vegetation, depth of vegetation, size of the woodlands to the north, the depth, the road, the woodlands, the cutting, topography, etc. It relates also topographically to Sandown Park in that it sits on the end of the subbridge, so there's a connection there. The Greenbelt assessments talk about separation and connection, and there's a connection in terms of the way this site relates topographically to Sandown Park, the adjacent residential area. It's separated from the wider countryside by the surrounding vegetation, but also topography. And as a consequence, the effects of sprawl are limited to the site. It is accepted that there would be, obviously, if the site is developed, there would be inappropriate development in the Greenbelt. But I do not think it would represent unrestricted sprawl. And it's because it's so contained by the firm boundaries which surround the site.
I mean, you've set those boundaries out. Is there any, do you need to or wish to highlight those, or are you?
I've mentioned them there. I mentioned them again in my rebuttal statement.
Well, they're in your proof at 7.6.4 to 7.6.16, and then I think your proof at 3.1.8, 3.1.12.
Yeah. So that was 3.1. Did you say my proof 3.1.12? Was that my?
No, 3.1.8 to 3.1.12 in your rebuttal.
Yes. Yes. Yeah. So I don't think there's a need to go through that again in further detail. Probably the most detail on that is in my rebuttal. So
yeah. Although for the inspector's note, you also deal with 7.6.4 to 7.6.16 of your proof.
Yeah.
So are you happy for us to leave purpose A?
Yes.
Purpose B, and this is brings in the Tunbridge Wells Hospital, is to prevent neighbouring towns from merging, and this is inspector's note for Mrs. Kirk's GBA Greenbelt Assessment, para 5.2.3. And I want to come back to a couple of points which have been clarified. If we look at her assessment there, 5.2.3, it's at the bottom, it's on page 12 going on to page 13. Do you have that?
I have it.
So she says further detailed analysis of the appeal proposals identify the glimpses of the site in Tunbridge Wells Hospital are both available from the A264, such that there could be indivisibility between the two settlements from Pembury Road. I think, in fairness to Mrs. Kirk, she now accepts there's no indivisibility. We thought that in chief across examination.
That's incorrect.
Yeah.
It's not indivisible.
So can you please, can I And then in terms of the glimpses, I think that's clarified as winter only.
Yes, Ms. Curtin clarified that to the inspector earlier.
Well, I think you've given your evidence on it. What you've dealt with summer and winter. What do you say in winter?
Well, we've obviously done a full assessment in summer and winter, and it's my position throughout this and in my proof that there's only the barest of potential glimpse possible from a very short section of the Pembury Road in winter only. And then, as we saw yesterday, there's no potential for summer views of the proposal.
So on the question of lack of interdivisibility, do you say to the inspector that this is a key element, insignificant element, or what?
It's key to the perception of various aspects of the Greenbelt purposes. The perception, for instance, of openness is obviously affected by where one can see it from. So, that, for instance, from the A264 Pembury Road, there would be no sense of any change in the perception of openness as a consequence of the development. In terms of merging, which is where we were looking at, there's a potential for the tiniest glimpse, barely visible, I'd say, of development on the site, and equally any views of the hospital are through trees. You can get a tiny glimpse of the hospital. We're talking about glimpses from places, if you kind of find the right place on the road here. If you're driving along the road, you wouldn't see it. Pretty unlikely to see it, I would say. So we're talking about whatever we're talking about here. It's at the very, very lowest level of effects.
And in terms of to prevent maybe it's a planning point or ultimately a legal point, I suppose, but prevent neighbouring towns from merging. It's now clarified in common ground that Tunbridge Wells Hospital is not part of the built development limits of Pembury village, even if we treat it as a town. Is that your understanding as well?
Yes, absolutely. Pembury is the village. For the purposes of the Greenbelt study, they called it a town. But either way, Tunbridge Wells Hospital and the other developments in that area are not part of the town of Pembury. It's not within the limits of built development.
And in terms of what Mrs. Kirk is now saying, that although the hospital is not part of the town or settlement, any development, well, the development of this site would cause harm to the gap between Sevenoaks and Pembury. What do you say?
Sevenoaks is a long way away, that's what I say.
Yeah, that's right. That's fair enough.
Sorry.
Well,
Tunbridge Wells.
What about Tunbridge and Morley? Yeah, go Tunbridge and Morley. No, Tunbridge Wells. Yeah, well, yeah.
As set out in section 7.6.17 to 7.6.22, something like that, of my proof. There's two aspects to this. One is physical, in terms of the physical distance that it would make, and in my proof I've looked at the percentage difference that there would be if one was to, from the edge of the appeal site to the edge of the built development. How different is that to the current distance between the edge of Sandown Park to the edge of the built development? And I've looked at the distance across the Greenbelt as well. In terms of the Greenbelt, the distance across the Greenbelt, it's an 8% reduction. So physically, it's a very, very small difference. I then move on to the issue of visibility. Do you want me to continue?
Yes, please.
In terms of the visibility, as I think we've just talked about, there would be no what I call combined visibility. So there's nowhere where you can stand and see Pembury and the appeal site from the same point where on the A264. So as an example, the bridge on the A264 over the A21, it's my position you cannot see the appeal site from there. We've done the photo wires, they make it plain to me that the appeal site proposals, even as they were currently proposed with the cone, which was going up to 15 metres, sits behind the trees that are in the foreground, you will not see it from there. But there's nowhere along that road or anywhere else along the Pembury Road where you would see both development of the field site and development of Pembury.
And I mean, there are there's, I think what's been said against you is, one, you don't take account of spatial openness, and two, well, let's take that first. Is it right that in your assessment you ignore the spatial impact of the proposed development?
Absolutely not. So for your note, my proof 756, and I'll just read the first sentence. In the case of the appeal site, should the proposals be granted consent, it is accepted that there will be a clear spatial infringement of the concept of openness. A bit further on, 7514, my judgment was there will be an undeniable spatial change. So we certainly consider the spatial aspect of it.
The other thing is, it said that, well, particularly in respect of this, when we were talking, it's probably all the purposes, but when I was asking questions of Mrs. Kirk on purpose B, to prevent neighbouring towns from merging, there are two issues. One, I think it's fair to say very little weight was given by her now to the the question of intervisibility and also visual connectivity in terms of this purpose.
Yes, that's absolutely the case, and it's clear from the judgment that she's come to that she's focusing very much on the site and on the spatial aspects of that.
What's your view on that, particularly in the light of the approach that the Council's own Greenbelt assessment had, which we've just been looking at in terms of interdivisibility along the A21 is a key element.
So the assessment within my proof is entirely consistent with the stage 2 Greenbelt assessment, insofar as it considers boundaries as part of the overall assessment of potential harm. The lack of visibility and the strong buffers in terms of the potential for merging clearly provide separation between the two. So not only have we mentioned the small percentage change in terms of the physical difference in the gap, but in terms of any visual aspect of it, there's no visual connectivity whatsoever. And therefore there would be no perception of merging as a consequence.
And then it said, well, the impact and now the grant of permission of Owl's Nest is relevant. Can you help us with that, please? Owl's Nest.
I suppose two things to say on Owl's Nest. One is, I think Ms. Kirk's evidence suggests in various places that when the stage 2 study was done, if they'd known Owl's Nest was coming forward and the allocations are coming forward, they would have considered it differently. Firstly, a note that in the stage 1 Greenbelt study, Owl's Nest is acknowledged within that. So clearly when they did the stage 2, they must have known, the stage 1 was obviously done before the stage 2, so they must have known about Owl's Nest and considered it. And equally, I have considered it in my evidence. And in terms of the allocation south of Pembury, I think we've established already with Ms. Kirk this morning that there is no intervisibility between the site and those allocations whatsoever. So I don't see why they would cause a change to the stage 2 assessment parcel TW5. Did I answer the question?
Yes, but not about Seven Oaks, but I'll forgive you for that. That's fine. Yeah, and you deal with that 3.1.13, 3.1.17 in your rebuttal as well. I won't take you to unless you want me to go to. I want to move on to purpose C, and this is the issue of to to assist in safeguarding countryside from
Can I
encroachment.
just go, there was a second point, I knew there was something there. Owl's Nest also is very, very well contained. It's a very, very wooded site. And as a consequence, that's one of the reasons why there would be no perception of visibility of Owl's Nest and no intervisibility with Owl's Nest. Not only is our site very well contained, but the Owl's Nest site itself is extremely wooded, extremely well contained. Where, you know, there will be no visibility of the site as a consequence of that. Sorry.
And just on that, is it proposed that Owl's Nest is taken out of the green belt by the council? Purpose C, to assist in safeguarding countryside from encroachment, and that's 5.2.3, third table, by Mrs. Kirk. Can I have your advice, please, to the inspector as to the approach Mrs. Kirk takes, please?
Well, Mrs. Kirk has, in her stage purpose C table, has, with one small exception where she's noted the appeal site, which has links to the countryside north and south, has basically accepted the TW5 stage 2 assessment. I, in my assessment, say that the TW5 stage 2 assessment, which obviously applies to the whole of TW5, it's greater than it would be if you were looking just at the appeal site. The appeal site being much smaller and more contained and more visually separated. My judgment is that we would have a relatively weak contribution, whereas the TW5 is a moderate contribution to that purpose. The appeal site, again, it's in my evidence, and the appeal site clearly has characteristics of the countryside, but there are, it's very, very visually contained. There's the lack of visibility to the wider countryside, and in my judgment, it's clearly urban fringe land rather than, it's countryside, obviously, in terms of planning countryside term, but it's urban fringe land in terms of its proximity to the settlement.
I mean, you've set them out, but what do you say are the urbanising influences?
The urbanising influences are Sandown Park itself, and in that sort of wider countryside context, the hospital and the Knockcut Garden Centre and the Mercure Tunbridge Wells Hotel, they all have an influence on the countryside setting, the wider countryside associated with this area of Tunbridge Wells.
In terms of boundaries, in terms of looking at safeguarding countryside from encroachment, again, I just like the advice, boundaries have any impact, and what do you say about the countryside?
So if I can, just for your note, point you to, it's actually on, well, it's 7.643, 29, flipping over to page 30 in my evidence. You'll see there I make reference to the issues of separation and connectivity. I say, as I consistently say, that the boundaries are highly relevant. They provide separation, and unlike along the southern edge of TW5, where the Pembury Road provides connectivity, there is no such connectivity created between the appeal site and the wider countryside. In fact, the containment of the site, which is so strong, means that there are very few views to the wider countryside. There's a relatively short view from where we stood on site yesterday, looking to the south towards the Pembury Road, albeit you can't see Pembury Road itself, but to the wider countryside context beyond that. There are no long views into the wider countryside. There are areas of the high weald, for instance, where there are long views out to the low weald, etc. There's none of that. The containment of the site created by the boundary features is so strong at this site that it reduces the effect on the wider countryside considerably. which is one of the reasons I've concluded a relatively weak contribution.
So I know ZVI we were looking at in terms of landscape, but what relevance, if any, does the agreed ZVI have for assessing harm to the openness of the green belt in your advice to the inspector?
It's relevant insofar as a small ZVI means that there is a very small area of the countryside where there would be a perception of the change. Whereas obviously a larger ZVI would lead to a greater area of perception, greater extent.
So we see throughout in the green belt assessments the concept of looking to the wider countryside is referred to, and there are a number of quotations of that from the green belt study. Again, your advice to the inspector is the study right, and more particularly would the inspector be right to look at the impact in the context of the wider countryside when looking at encroachment into the countryside?
Absolutely, he would. So if I can just, for your note, point you to the stage 2 greenbelt assessment, CDO 522, page 24, which is the methodology that looks at purpose 3. You will see under various the things, for instance, under relatively weak, it says the parcel relates more strongly to the settlement than to the wider countryside. Elsewhere it says the parcel relates more strongly to the wider country. It's talking about the wider countryside in the scale that they give there.
And I think you've covered that 3.1.18 in your rebuttal and 7.634 to 7.651 of your proof. Is there anything you want to say further on that purpose within the countryside, including that within the green belt, or we go on to purpose D?
No, I don't think so. I think we've covered it.
So D then, preserving the setting and special character of historic towns, you're in agreement, relatively weak contribution.
We're in agreement with, as Kirk said, with Ms. Kirk and TW5 with the assessments.
Yeah. So then, can I just finally then take you to overall in terms of impact on openness? It's there's reference made to the planning statement. I haven't dug it up, but is it your case that there's absolutely no adverse impact on the openness to the green belt on this proposal?
No, clearly not. And I referred you, sir, to the acknowledgements of a clear spatial infringement earlier. I think Ms. Kirk summed it up well. Actually, we're in agreement that there is harm. It's just the level of harm which is where we're in disagreement. So we agree there is a spatial infringement, but the overall, as a consequence, largely of the boundaries and the containment and the limited visual perception, I say the level of harm, there'll be low level of harm to the openness of the greenbelt overall, although clearly on the site itself that is different.
So I think the position in Mrs. Kirk's is substantial, and yours at 7. We go to your 756. Your proof of evidence.
Yeah.
Such a clear spatial infringement on the concept of openness, or the extent of the visual impact would be restricted to the site itself, very small area of surrounding countryside, and you refer to the ZVI. Only a very limited public access within this area, only a very few number of private properties for which proposals would be seen. In terms then,
I'd like to point the inspector to the reference that might be useful there.
yes,
So if you look at paragraph 759, where it flips over onto the top of page 19, there's a quote there from the council's strategic study, the stage 1 study, about it's talking about the hotel, the Knockcuts Garden Centre, I think in that case, but there are other references to sort of in the wider Greenbelt there. And there's a footnote 75 there, which gives you the the reference to those quotes. I think they're worth just noting there. Well trees surrounding limits the impact of development on perceived openness.
trying to find out which paragraph was that?
In my proof, page 19 at the top,
Yes,
it's actually part of paragraph 759, which runs over.
yes. And the quotation is World Tree, which is the Mercure Hotel and not.
It's a quote from the strategic Greenbelt study.
Could we just go then to 3, whilst we're here, 3.1.31.
This is my rebuttal.
In your rebuttal, yeah. I just want to invite you with there's typographical error there.
Sorry. Yes, there is. In the middle line there, it says, I agree, however, that from the track between the two parts of the site, and then I've said the avenue in brackets, there would be no significant change. I mean, a significant change. So we entirely accept that there would be a change on the site and from that track. But it's from the wider landscape that we say that the change would be graceful.
Thank you. Mr. Gibbons, is there anything you'd like to add at this stage?
No, I think we've
Now we've come in 50 minutes out. So thank you very much. The inspector may have some questions, and my learned friend have some questions as well.
It's in me, or is it quite warm?
I think it's quite. I was hoping it's not just me. I was just wondering if I had a COVID attack coming on. I was feeling quite suddenly getting quite warm.
Someone's in the windows.
Yeah, can I shut this blind?
Yeah.
The lights are just because the sun's.
Yeah. There's no air conditioning or anything, is there? No. Okay.
Well, no, we decided against that because of the noise.
Okay.
The microphones.
Okay.
And is there any merit in having these doors open? I mean, somebody came and shut it earlier, but
We could open the doors
Yeah.
because there
Was
should
it
be
a noise
anybody
issue?
walking backwards and forwards. Well, this is in use for us. There's no reason apart from the odd
Okay.
facility.
No, because we're
person.
cut off, aren't we?
Yeah.
Get a bit of a flow going.
Try it.
Well, yeah, something like that.
yes.
I think it's much warmer, isn't it? I put that jacket off.
So yes. Wait to see this change.
Yeah.
Thank you. Mr. Gibbons, I'm going to the same questions I asked Mrs. Kerr. What's your understanding of reference to encroachment? What does it mean in the context of the framework definition?
Sorry, could you, that last bit of that, I missed it, the window's been opened.
I'm asking the same questions as Mrs. Kirkby, which is about encroachment.
Yeah.
And what is your understanding of what encroachment means in the framework as being within one person?
Encroachment would, in my understanding of it, means spreading of development into the surrounding area.
And in this context, what would you understand to be the surrounding area? Oh, sorry. Well, you can. What in your definition? What do you mean by development? Spelling of development.
In terms of green belts, there are certain things that are allowed within green belt within the MDBF. So in terms of encroachment, short of going through all the detail of that, I guess we're talking about built form. In terms of development, we're talking about built form.
So spreading of built form, just to put a different view on it, into the surrounding area.
Yes.
And what would you say to the point that Mr. Jones put to Mrs. Kirk this morning about the extent of that countryside, definition countryside around?
I would say that it applies to all countryside that is a surrounding area. I wouldn't actually put a limit on it to 500 metres or anything. I would say it applies to all countryside. So when you're looking at the effects on wider countryside, they could, I mean, to an example, so there could be a situation where perhaps there's a valley and then there's countryside seen in the distance further away. That's not the case here, but that would still form part of the wider, what I would call the wider countryside.
You describe the area as urban fringe, the site as urban fringe, rather than countryside.
I see it as countryside in terms of planning, because obviously it sits outside the limits of development. But in terms of its the characteristics of the area, I see the characteristics of the area as urban fringe. Clearly, the site is it has characteristics of countryside. It's currently under agriculture, so it has the characteristics of countryside in that sense. But in terms of the area, we've got the urban edge and the A21 and Pembury, etc., etc. So I consider us to be within the urban fringe. I think in my proof I refer to it as urban fringe or urban rural fringe, peri-urban. It's that edge of.
Does the quality of its landscape also come into that definition?
No, not from a greenbelt perspective. That's obviously in terms of LVIA, it very much so, but from a greenbelt perspective, the quality of the landscape is not relevant, I suppose.
Where would you see that beyond the site? Where beyond the site would your view of urban fringe go?
It depends which, to some extent, which direction we're sort of heading in. I mean, the urban fringe area for me is that area where we have development and then you're getting into the edge of countryside and there's more bits of development, if that makes sense. So, I mean, in this scenario, we're looking at a piece of land between Sandown Park, which obviously is connected to the wider Tunbridge Wells main urban area, but then as we look to the east, we've got the A21 and the development there. So we're in that zone, if that makes sense. Once you get beyond the Tunbridge Wells Hospital, for instance, and you move out into the wider landscape, that's where you're moving more away from the urban fringe and into countryside.
Mr. Gibbons. Any questions? No further questions at the moment. Thank you. Would you like a break before we start cross-examination, Mr. Gibbons, or do you want to consider?
I'm all right to go on now, sir, but if I need one in half an hour or an hour, I'll let you know. Is that okay? It would only be a short comfort.
So can I just ask one thing, Mr. Gibbons, just slightly arriving out of what you asked before he's cross-examined, or I do it in re-examination.
Is that okay with you? Yeah.
Just so it would be easier, but I don't know, Mr. Gibbons, in terms of example you were giving with the valley and wider countryside, I wasn't clear. Were you talking in general terms or in reference to this particular site?
I was talking in general terms. In terms of this site, there is obviously, as it turns out, a valley to the south of the site, but there's no sort of long view across that valley. I was talking in general terms about long views to somewhere further afield. I mean, obviously there is also a point where view becomes so far away that it would, again, the impact would fall away, so to speak. But I was giving a general example.
Thank you very much. I just remind.
So I'll look to break in about half an hour, does that make sense?
Yes, yeah. You chose the appropriate time
Around
in terms of your cross-examination over the break.
Thank you. Good afternoon, Mr. Gibbons.
Good afternoon.
Just in terms of documents, obviously your proof and your appendices, Mrs. Kirk's appendices.
Them all.
Got them, and I'm sure you've got the Greenbelt assessments, and we're going to look at a couple of decision letters and judgments in series 6. You might not have those in paper form, you've got the laptop there so that you can get to those pretty easily, I hope. And in terms of the structure, I'm going to explore how you assessed harm to openness, and then exploring the contribution of the site to the purposes. So starting then with openness, we can agree that paragraph 137 of the MPPF tells us that the fundamental aim is to prevent urban sprawl by keeping land permanently open.
That's right.
That is the underlying policy objective of the Greenbelt, isn't it? Keep land permanently open.
Yes.
And then can you have a look, please, in series 6 at CD 0611.
Haver Hill Road.
That's it. I'm sure you're pronouncing it correctly. I've got no idea how to
Well,
pronounce
I'm in Haver Hill, I ought to know it.
it. Good. So paragraph 8, please. First sentence, openness is a fundamental aim of Greenbelt policy, distinct from its 5 purposes. Do you see that? Distinct from its 5 purposes. So we've got the overall aim, permanently open, and that is separate to the purposes of the green belt, isn't it?
It says yes.
Now, we've agreed that, keep that open for now, we might come back to it. We've agreed that this development is inappropriate development, and therefore, from paragraph 147 of the NPPF, that is by definition harmful, isn't it?
We agree that.
And we can agree, can't we, that there can be situations where there is definitional harm, but no actual harm. For example, what about replacement permanent building of a caravan of the same footprint and height?
Yes.
Definitional, but no greater impact on openness.
Yes, certainly. Yeah. That's a target.
So where there's actual harm, that harm is additional to the definitional harm. If I'm straying outside what you think is your expertise, you just
No,
say
you're playing with the words, but I guess you're correct. Yes, it's additional to the definitional harm. Tool harm.
Thank you. And can you have a look, please, at core document 0610?
Can you tell me what that is?
Yes, it's a Seven Oaks decision letter, Broke Hill Golf Course. We're going to Seven Oaks.
Thanks, Alex. 0610, did you say?
Yes, 0610. And paragraph 17 comes underneath the title Impact on Openness, the subject of impact on openness. And paragraph 17 says, although there's no definition of openness within the framework, the guidance refers to assessments of openness as being informed through consideration of spatial and volumetric aspects, the duration of the development, and the degree of activity likely to be generated. Whilst only a suggested framework for consideration, it is useful to inform consideration of issues involved in this appeal. And I see you mentioned those aspects when you referred to the PPG in your proof at 7.5.4. We can agree those are all relevant to considering openness, aren't they? Volumetric aspects, duration of development, degree of activity likely to be generated.
Yes, I think that's fair.
Good, so we'll come back to that. And then please, can you open up 0654, which I think you refer to in your appendices as well. That's the judgment Turner.
.54, did you?
0654. Just let me know when you're there.
Have it.
Thank you. And I hope we don't have to take time introducing it because you have referred to it in your proof. But if we look at paragraph 24, this is where there's a quotation from another case from Mr. Justice Sullivan, who then was. And what is said there is that if the approach the officer used was adopted, then the green belt will suffer the death of 1,000 cuts, while it may not be possible to demonstrate harm by reason of visual intrusion as a result of an individual, possibly very modest proposal. The cumulative effect of a number of such proposals, each very modest in itself, could be very damaging to the essential quality of openness of the green belt and metropolitan open land. See that?
I certainly see it.
Good. And then if we carry on to paragraph 25, which is the conclusion of this court on that. Paragraph 25 says this remains relevant guidance in relation to the concept of openness of the green belt in the NPPF. I'm not going to read every word. The absence of visual intrusion does not in itself mean that there is no impact on the openness of the greenbelt as a result of the location of a new or materially larger building there. But as observed above, it does not follow that openness of the greenbelt has no visual dimension. So my question is this, Mr. Gibbons. Openness, we can agree, is concerned with both spatial and visual impact. But if there is no visual impact and there is spatial impact, there is still harm. Yeah.
It is still harm. We've never said there's not harm.
No, I'm going to move on to where I think the main difference between us is. Spatial impact on openness and visual impact on openness do not net off against each other, or as Mrs. Kirk put it, they don't cancel each other out. And there's no authority, unless you point me to one, I haven't found one, there's no authority that says that if there's low visual impact but high spatial impact, the overall conclusion is brought down in terms of impact on openness of the greenbelt.
Going back to your point about netting off, I don't think we've ever suggested that they would net off against each other.
Good.
In terms of the bringing down, I think we accept that there is a spatial impact and we accept that there are clearly visual effects on a very small area. But I maintain that there is a very small area of the surrounding area of our countryside greenbelt that would be affected. So the perception of that change would be very small.
It doesn't, when you talk about the perception of that change being very small, is that not in relation to the visual impact?
Yes, it is in relation to the visual impact. Perception is obviously largely, not entirely, but largely as a consequence of visual impact.
That brings us back to the point that we were making before, and also the point made about death by 1,000 cuts. That just because you can't see something in greenbelt terms, impact on openness still occurs, doesn't it?
We've not said there wouldn't be an impact on openness. We haven't got before us. I mean, there was a suggestion of death by 1,000 cuts, that would be just cumulative. The suggestion that the allocation south of Pembury were going to somehow be cumulative. That I don't see any cumulative build up there as a consequence. The focus is obviously on the effects on the site, but we accept that there will be effects both spatially and visually, but the perception of that change will be very small.
Can you look at paragraph 7.5.14 of your proof, please? You know, you've got it.
Sorry, could you just, sorry, I just said it's 14.
7.5.14.
I've got it.
So that's where you say there's an undeniable spatial change but limited visual change. And then we get to 7.5.15. Overall, I therefore conclude that there would be a low level of harm to the openness of the greenbelt. So, I mean, correct me if I'm wrong, Mr. Gibbons, but we read that as you combining the judgments of spatial change with visual change.
I'm not combining them. I think, again, it kind of almost goes back to our discussions around some of the landscape impacts as well. I think there's a difference between obviously the effects that there will be on the site and the site itself and the effects on the wider landscape. And I'm looking at this in that wider context, looking at the overall perception of it. And therefore, whilst I acknowledge there'll be a spatial change, I say it'll be on a very small area of the landscape, and that in terms of the perception of that change will be very small.
So I can try and understand that. You've said that there's an undeniable spatial change and a limited visual change. What is the scale? What does undeniable mean? What is the scale of the spatial change?
I wouldn't put a scale to them. Undeniable means that there is going to be a spatial change. If we put buildings on the site, clearly there will be a spatial change to the openness of the greenbelt.
I'm going to explore this in a moment with you, but for the moment, before I take you to the various elements of it, can you not give it whether it's a moderate spatial change or a significant spatial change?
Sorry, on the site?
Yes.
On the site itself, there would be a fairly significant spatial change.
Fairly significant. And then you said, you asked me, when I asked you that question, you asked me on the site itself. So you make a distinction between the spatial change on the site itself and the spatial change beyond the site.
No, I don't make,
Okay.
there's no spatial change beyond the
Exactly.
site.
Exactly, so it must be on the site itself. That's what
Yeah,
spatial
I'm
change
just
relates to,
making
doesn't it?
sure that there's a spatial change on the site.
Yeah.
We accept that.
And we don't
Always
need-
have done.
And we don't need to think about spatial change outside the site because that can't happen, can
We're
it?
not changing anything outside the site, so there's no spatial change.
So we've got a fairly significant spatial change on the site, and we've got a limited visual change, and that brings you to a conclusion of low level of harm.
The limited visual change on the wider landscape, yes. So there's a spatial change on the site.
Yeah.
Perception of that change from the area around it is very small because the ZBI is so small and it's all very contained. And therefore, the overall effect on openness is, I say, a low level of harm.
Okay. Let's explore that a little bit more. 7.5.6 of your proof, please. So this is where you're looking at the spatial change here. You mentioned, sorry, 7.5.5, you mentioned the volume of the structures above ground. Now, in terms of development above ground, it's not just volume of structures, is it? And if we need to go to a decision letter, we can, but also included would be the permanent built form of roads and car parking, wouldn't it?
Interesting, I didn't put it in my proof, but that's where that hangs over from, the volume of structures above ground. I did have an appeal decision that talked about a road in Greenbelt and the road not having a spatial change, but apologies, it was talking about the road not having spatial change and the vehicles on that road having an impact. So the cars, etc. It was saying if it's below ground, it's not having a spatial change on but I didn't put it in my proof, so we can't refer to it.
0622, please. Call document 0622.
Oak Farm.
Yes, that's the one. Paragraph 16, under the subtitle openness. And mentioned there in paragraph 16 is not just the 19,000 square metres of floor space and accommodation ranging between 1 to 3 floors. It also says the buildings would occupy large parts of the site, spread around in blocks of development, along with car parking and the access road. So this inspector plainly thought that built development was relevant to openness.
I haven't read the whole judgment, but that's what it says there.
There is currently a pillbox on site, but we can agree that overall this site is an undeveloped site, isn't it? So we see approximately 10,000 square metres of buildings, and then in addition to that, the car parking and the roads. That is significant compared to its current undeveloped state, isn't it? Now thinking about the PPG guidance and the duration of the development is permanent, isn't it? It's not something that's going to be there for 10 years like a solar farm and then come away.
Yes.
And thinking about the PPG guidance and remediability, again, same point. Nothing's being remedied, is it?
It's not temporary. There's mitigation in terms of planting proposed around boundaries, but it's not temporary.
And then lastly, the degree of activity likely to be generated. And I think that's what you were talking about in relation to the other appeal decision you were talking about, where the cars were considered part of impact on openness. because activity does include things like traffic generation, doesn't it?
Activity does it.
Yeah. And currently there's no traffic on site, is there? No. And being introduced will be parking for over 100 cars, staff coming and going, people coming and going, visitors, deliveries, site facilities, deliveries for occupiers, a high degree of activity compared to its current use. Can we agree that?
Yes.
So we add to the built form durability, lack of remediability, and the degree of activity, and those are also significant in openness terms, aren't they?
You don't, I think you don't add them all together in the same way. You know, you said do you just subtract one against the other? They all sort of contribute absolutely to an overall level of significance.
Overall level of significance. Now, in your paragraph, you've got 7.5.11. You talk about the landscape surrounding the appeal site already including significant development, don't you? You list a number of elements.
I do.
You say it's significant development and substantial areas of built form within the green belt. So that's what you say in 7.5.11. And 7.5.12, you say that the openness of the green belt is already impacted by development, and in this wider sense, the perceived change to openness associated with the development of the appeal site would therefore be even more limited.
That's what I say.
Yeah.
I think what I mean there is fairly clear, which is the area is, I think we had a discussion about urban fringe, and I described it well. You know, it is an urban fringe area, and therefore we're not dealing with, you know, a field in the middle of the countryside somewhere where, you know, so there's that element of it's all, you know, we're looking at a landscape that already has that urban fringe nature.
I understand that, but urban fringe suggests a landscape quality judgment, and we're dealing with openness here, Mr. Gibbons. And my suggestion to you on reading your 7.5.11 and 7.5.12 is that there's no authority, policy or guidance which says that development elsewhere in the greenbelt affects the spatial calculation of new inappropriate development in the greenbelt. This is irrelevant to the spatial impact on openness, isn't it?
I think the word there that's relevant is the word perceived. I'm talking here about perceived change, perceived openness. And again, I would perhaps point the inspector to page 19 on the previous page, and that footnote I referred to earlier, where the council's stage 1 strategic greenbelt study talks about impact of development on perceived openness. So it's the perceived, it's the that issue of perception of change that I was focusing on there.
So visual, not spatial.
I think we've already agreed that there's only a spatial change on the site itself. So we're talking about perception.
Yes, but if you're talking about elements of built form around the site and the impact of those on the site in some way, reducing impacts on the site because of what's around it.
I'm not saying it reduces impacts on the site, am I? I'm saying it reduces the perception in the landscape. So when you're in that landscape, moving around the landscape around the site, one's perception of openness is influenced by the other things around it.
So to be clear, spatial impact on openness is not affected by other built form in the surrounding landscape.
We accept that there is obviously a spatial impact.
Good. Right, on visual impact, please, can you look at 0625, which is the Westmoreland decision? Let me know you've got that.
That's open.
And paragraph 13, please.
Sorry, is it 13 or 13?
Paragraph 13, but just so that we're clear, from the first page, we can see that this was, from paragraph 1, we can see that this was planning permission being granted for an extra care development of 79 units.
Yes, I see that.
Yeah, and then paragraph 13, so this is under the section Greenbelt. And paragraph 13 is talking about visibility. See that?
Yes.
And at the end of that paragraph, 1, 2, 3, 4, 5 lines from the bottom, the inspector says the scale of the built development and associated parking areas and the associated reduction in openness would also be very apparent to the many residents, staff and visitors at the development itself. The visual and spatial harm to openness would therefore constitute significant additional harm to the greenbelt. So it's also relevant, isn't it? The visual impact is not just about what's around the site, but also what happens on the site.
Yes, and that's acknowledged in my proof.
And that doesn't matter whether the site is well contained or not. Whether the site is well contained might apply to visibility outside the site, but in terms of those using the site, the matter of it being well contained doesn't affect the impact on there, the visual impact on there. Thank you. And here, in addition to staff and visitors and so on, there is also public access, isn't there?
Yes, there would be.
Good. So I don't go back over the views of the site from Pembury Road. There's clearly a difference in opinion between you and Mrs. Kirk, and the inspector will have to make up his own mind about that. But you've set out, as we just looked at, a low level of harm to the openness of the green belt, a position which appears to be influenced by your assessment of perception of openness. Yeah. But even on your case, you do find harm to openness, don't you?
Yes.
Thank you. So I've finished the section on openness. So I think this is a good place to break before I move on to the next topic.
Okay, that's good. Should we take a 15-minute break? We'll return at 4:05.
Good afternoon again, Mr. Gibbons. Have you got your MPPF handy? So just before we move on to the purposes, just a few questions about boundaries. Paragraph 140, page 41 of the MPPF. On my version. You got paragraph 140?
I do, sorry.
That says that greenbelt boundaries should only be altered where exceptional circumstances are fully evidenced and justified through the preparation of updating plans, doesn't it?
It does.
Part of evidencing and justifying greenbelt boundary release is through greenbelt assessments, isn't it?
Yes.
Yeah. And then it says that strategic policies should establish the need for any changes to greenbelt boundaries having regard to their intended permanence in the long term. Yeah.
Yes, that's what it says.
You say at your paragraph 7.6.13, which is on your page 22. You got that?
Yes.
It's your opinion that the A21 would form a better edge to the built-up area, which is both physically buffered by the road and naturally buffered by existing vegetation, and would provide a strong defensible edge into the future. So my understanding is you're saying that the A21 would form a better boundary to the green belt, is that right?
Yes.
Now, this inspector can't change the green belt boundary through this process, can he?
That.
Yeah.
I appreciate we're not talking about actually changing it in this.
In this appeal, what we have is the boundary is where it is, isn't it? And the A21 is not the boundary.
Sorry, last bit.
The boundary is where it is, as we see on maps that we've looked at today, and the A21 is not the green belt boundary at the moment.
It's not the green belt boundary at the moment, but it clearly is a physical boundary on the ground on site. So it's important in terms of making any judgments of the harm. But yeah, you're right.
We'll come back to that.
We're not proposing to change
No.
the green belt. I think we know.
But the green belt assessments that we've been looking at over the course of today must consider how boundaries might be changed because releases are taking place, and those assessments therefore are looking at the quality of boundaries, aren't they?
They are, yes, absolutely.
Now this appeal site to the south does have an open gap in the southwestern corner, doesn't it?
It does.
And therefore it does not have a strong boundary for greenbelt purposes to the south, does it?
To the southwest, no, but it is proposed to be planted, which is taken into account in considering the likely harm.
How long would that take?
Planting.
Yeah.
It will obviously depends on how well it grows, etc. But it will take a while to grow up. Depends on the heights, we look at in LDIA terms, we normally look at 7 years, 15-year type periods. I mean, it's a period of years.
Yeah.
But we would strengthen that boundary. And so if I just point you to, there's no need, I don't think, to go to it, but an example would be on page 97 of the stage 3 greenbelt boundary, which is looking at one of the parcels along the southern edge of Pembury, paragraph 4201. It says, presence of this strong boundary will limit impact. It says, so they're talking about a strong boundary in that case, but it also says, and the proposed landscape buffer to the south of the site will limit any potential impact on adjacent greenbelt land to the east. So the council's stage 3 study, when looking at boundaries, has been saying, okay, we've got a buffer here. Yeah, it's accepted. Obviously, it's going to take some time to establish, but that's accepted. That's considered in their assessment of harm.
And that's considered in the round when they look at harm. But I just want to ask you again about this boundary and how long this one would take to plant up so that it was a strong defensible boundary in greenbelt terms with the necessary width and so on to join up with the rest of the boundary. How long would that take?
To plant or to grow? I mean, it'll take
Both.
a matter of days to plant it.
Okay, how long to grow?
To grow, it's going to take a number of years to grow into something of width and substance.
Yeah, I know it's a number of years, but how many years? Approximately.
Plants grow, don't they? They start small and they grow. So
we said we talk 7 years or 15 years. What are we talking about? 7 or 15?
Well, in 7 years' time, it would, if you planted a typical woodland mix, it might be between 2 and 5 years, like 2 and 5 meters in height. In 15 years' time, it might be between 5 and 9 meters in height, something along those lines.
Thank you. Right, let's just move on to purposes, and just a matter of principle before we do. CD 0611 again, Haverhill Hill Road.
I have it.
Paragraph 7.
I've got it.
Halfway down, it makes no difference which or how many of the purposes of the greenbelt would be harmed. And so I do not need to adjudicate between the parties on whether more than one purpose of assisting in safeguarding encroachment which would be harmed in this case. I concur with both parties that at least one purpose would be harmed. So it doesn't matter how many are harmed, one is enough.
Yes, and that's consistent with the stage 2 greenbelt study process methodology. Sorry.
Good. Now, purpose A, to check the unrestricted sprawl of large built-up areas. And I note that you quote from the PAS guidance on this. Can we just turn that up? That is one of your appendices and its core document. This is a mouthful. 0711 02 13.
You happen to have my appendices reference numbers, it's CABC.
It's 11 02 13 N. So let me know when you've got it.
I have, yeah.
I'll just wait for Mr. James to type up.
I've got it.
Got it. Page, first sort of page of that, where there's a pretty picture. It says planning on the doorstep, the big issue is greenbelt. Greenbelt continues to be a huge issue for councils and communities across the country, an issue that councils face regularly on the doorsteps of their electorate. This advice note looks at the reality of plan making in the greenbelt, how planning process works with greenbelt issues, and the potential inclusion in development plans. This document is about plan making, isn't it? Not about development control.
It talks about the greenbelt generally, but that's what it says on the front.
Dated February 2015, we see at the bottom there. And then your paragraph 7.6.8 is where you refer to the PAS note on green belts. And on page 22, you say that it poses the question, is development that is planned positively through a local plan and well designed with good master planning sprawl? And then if we scroll down to where this is discussed, page 6. The terminology of sprawl comes from the 1930s when greenbelt was conceived. I think that's a mistake there. Has this term changed it in meaning since then? For example, is development that is planned positively through a local plan and well designed with good master planning sprawl? So this was about exploring the definition of sprawl, wasn't it?
Posing a question.
Posing a question, but the question that you didn't note in your paragraph was that it says, has this term changed in meaning since then, for example? So it posed two questions, didn't it?
It did, yes.
Now, your site is not development planned positively through a local plan, is it?
No, this is not part of the local plan.
Good. Now, at your paragraph 7.611, you say that the appeal site is separated from the wider countryside by Robinsgate Wood and trees and landform to the south.
Yes, I'd say by the A21 to the east, Robinsgate Wood to the north, largely separated from the landscape median to the south, southern part.
And at 7.6.9 above, you say the site is contained by natural features surrounding it on 4 sides.
I do.
If the site is contained by natural features surrounding it, obviously with the exception of a gap to the southwest, there is no relationship to the urban edge, is there?
I disagree. The relationship to the urban edge does not just mean a visual relationship. It's a relationship with an urban edge is far more about, there's perceptual aspects to it. You can't parachute into a site. Well, some people can, I suppose, but generally you don't parachute into a site and find yourself in the middle of, so you have context of what's around you. So that a site next to an urban edge, and this one is immediately adjacent to the urban edge, has the context, and therefore I say it's connected to the urban edge in that sense.
We've discussed boundaries, and you heard Mrs. Kirk's evidence about stage 1 assessment at para 420, which said that roads like the A21 do not function as boundary features, as usually settlement lies on both sides. Can you just have a look at Mrs. Kirk's plan HDA 5, which is CD 081103?
Could you take me to that quote just before we do, where that came from?
Yes, it's core document 0521.
Yeah.
Page 20, paragraph 4.20.
Just remind me what 0521 is.
Greenbelt assessment stage 1. Quote Mrs. Kirk was provided in her evidencing sheet.
Page 20.
Page 20, paragraph 420. Now HDA 5 is 081103. You've got that. It's Mrs. Kirk's appendix 3. Yeah, her appendix 3. I just want to look at. Have you got it?
I do have it.
Okay. Just want to look at the A21 in this area, in the right hand diagram. So in the right-hand diagram, we've got this proposed development shown within the appeal site. Yeah.
Yes.
Yeah, and we've got Owl's Nest shown as well, haven't we?
We do.
And then we've also got the garden centre on there as well, further to the south, east, and then beyond to the northeast, we've got the hospital as well. But just looking at the section of the A21 where the development would be with Owl's Nest on the other side of it, a boundary is a line to say that development can come up to it. An example would be a settlement boundary. If you've got a settlement boundary with the settlement coming up to the boundary, if you've got development on the other side of the settlement boundary as well, then the boundary is no longer performing a function, is it? There's settlement on both sides of it.
I see what you're saying in terms of I suppose it's I mean, if it's a drawn settlement boundary, if it's drawn as two boundaries, then it's two boundaries. If it's drawn across the feature, then clearly that's perceived to be the settlement.
Yes. And here, if we've got the appeal site drawing the development to the east towards the A21, and then we've got the development around Pembury to the east of the A21, including Owl's Nest, including the hospital, and then we've got the garden centre there as well, and then obviously the proposed allocations are shown there as well. But what we see here is that with development on both sides of that line, it's no longer a boundary. The development of Tunbridge Wells has sprawled out, and there's no edge to Tunbridge Wells here anymore.
Well, firstly, my response to that is all the developments you're talking about to the east are all washed over by the greenbelt. So we're not talking about a greenbelt boundary there. You've drawn on HGA 5, there's a blue line drawn around, for instance, the ALPE6 and the Owl's Nest site, but it's all washed over by greenbelt, so it's still greenbelt, as is our site, obviously, in this scenario.
Can I just pause you there?
No, could I answer the question? I would also point you to, I suppose, consistency of approach. The council's stage 2 greenbelt study, using TW5, for instance, that's CD 05-2205. I'm sure everybody's got that. At the very bottom, it says the existing edges staggered around the edges of residential gardens, blah, blah, blah. But the outer edge of the parcels, the A21 and the A26 would form stronger boundaries. So the approach taken in stage 2 greenbelt assessment is that absolutely the A21 would be a boundary.
I just wanted to pause you on Owl's Nest. Owl's Nest was previously developed, wasn't it? That's why it doesn't come out of the greenbelt. Now, you took us to TW5, CDO 52205, and then can we also have open, please, the assessment for Pembury, which is 052202.
Sorry, when you say Pembury, do you mean PE6?
Yes, please, P6, yeah. It's within that whole assessment for Pembury and that, yeah. So yes, if you turn to PE6, I think it's about 14 pages in. There's no page numbers on it, unfortunately. So first of all, each of these assessments was done individually. There wasn't a consideration of cumulative development, was there? There wasn't a consideration of TW5 in conjunction with PE6.
The way the stage 2 process was done was different from the stage 3 process, as I said earlier. So the stage 2 process looked at the boundaries as part of the overall process. So they were done individually in that sense, yes.
Yes, so the answer is yes, because we're looking at stage 2 when we're looking at these assessments here, aren't we?
Yes, we are.
Thank you. And then we see, don't we, that in terms of the reference to the A21, it's referred to in both parcels, isn't it?
Yes.
The A21 cannot be a strong boundary for both TW5 and PE6.
I don't entirely agree with you, I'm afraid. It's stood on the ground. The A21 is a strong boundary. It's a physical boundary. It's a dual carriageway. It's in cutting. It's visual boundary because of all the woodland, etc. That is found along it and also to the east of it. So it continues to act as a boundary. There would be no perception of the two being one, if that makes sense. It continues to act as a boundary in real terms.
Okay, that's your position. We haven't got very much time, so I'm moving on from it. The inspector has our point. In terms of TW5, looking at the plan for it, which is on page 1 of 052205,
Yeah.
It has development on two sides, doesn't it?
It does.
Whereas the appeal site, as we discussed earlier from your proof, is contained on four sides by vegetational countryside, isn't it?
It's got strong boundaries. I still maintain that it's got, you know, it's got, I think we've agreed, a moderate boundary along the western edge with against Sandown Park, but it's still boundaries and there is still a development immediately adjacent
On the appeal site.
on the appeal site.
Yes.
That was what you were asking me about.
Yes, but in I'm not so much on boundaries now, I'm more on relationship with its surroundings. In terms of the wider parcel TW5, there are more sides directly adjacent to the settlement than the appeal site. The whole of the western side of TW5 is against settlement, isn't it?
Yes, but it's, of course, it's a much bigger parcel. So it's a bigger boundary, it's a bigger parcel.
And to the south, it is not as, to the south of the appeal site is trees and countryside, whereas TW5 subsumes that appeal site. So to the south has a road.
Correct.
Yeah. Okay. Can you turn up Mrs. Kirk's Appendix 3, 081103, Plan 2?
Yes, yeah. And 2.
Yeah. An aerial photograph.
I have it.
And from this aerial, it's possible to see that TW5 is particularly influenced by the settlement in the southwestern corner, isn't it?
That goes exactly with what I was saying about the connection along Pembury Road. It's the southwest, the southern edge and the southwestern corner, yes.
So whatever the assessment of the wider parcel, there are distinctions that can be drawn in terms of factors like association with settlement, which are different for TW5 as compared to the appeal site.
Yeah, I mean, it's exactly the point. It's exactly the point I make in my evidence that in 7.3.10.2, which is the note I gave you earlier, sir, about the relationship with the Pembury Road and the connection that makes and the adjacent land. You know, you're saying there's a difference. I'm saying there's a difference. Yes, there is a difference. It's arguable that they obviously didn't, but TW5 could have been split into, say, two parcels when they did the assessment.
The point I want to make with you, Mr. Gibbons, is that because there are differences, it is perfectly possible to come to different judgments in relation to TW5 than for the appeal site.
It's possible to come to different judgments. I think we've made the point that the level of those judgments, the level of harm created by developing the whole of TW5 would clearly be somewhat in excess of the level of harm created by developing the field site.
Well, that's your position, and Mrs. Kirk has her position, and she's explained why. But I have a point. Thank you. Purpose B, preventing neighbouring towns merging into one another. On page 24 to 26 of your proof, you set out distances between greenbelt boundaries in your figures.
Correct.
And you note the PAS guidance at 7.6.22 of your proof recommends avoidance of a scale rule approach. We just turn up that PAS guidance again, please. 07, 11, 02, 13.
I have it.
Page 6. And we're in the purpose to prevent neighbouring towns from merging into one another. in the second line, we see a scale rule approach should be avoided. The identity of a settlement is not really determined just by the distance to another settlement. The character of the place and the land in between must be taken into account. Landscape character assessment is used by analytical tool for use in undertaking this type of assessment. So land that's not within settlement boundaries is also relevant, isn't it?
Yes.
Yeah.
And this is exactly the point that we're making when we, when we look at the boundaries and the character of that landscape. Not only is it topographical, there's no visual connection or physical connection. If we develop the appeal site between the appeal site and Pembury, we're looking at here at the potential to prevent neighbouring towns merging into one another. There would be no possible sense of those two things, the two sites merging, Pembury and the site merging into one another. This, in some respects, what you just said supports that. If you didn't have any features in the landscape in between the two, and you could see between the two, there would be a much greater chance of the perception of merging. What we have is a landscape where there is no perception because of all the boundary features and the vegetation.
At your 7.6.24, you say that it's acknowledged that development of the appeal site would close the physical gap between Sandown Park and the hospital to a greater degree than to the edge of Pembury itself. And then you talk about the visual connection between the two. But just pausing there, if it's right and character of land in between and around is relevant, that includes the influence of the hospital and the other development around as well, doesn't it?
Sorry, can you repeat that?
Yes. So we just looked at the PAS guidance in relation to looking at the identity of a settlement, which is not really determined just by distance, but looking at the character of the place, and the land in between must be taken into account. In terms of Pembury, whilst the hospital isn't, and by the way, it's Tunbridge Wells Hospital at Pembury. Whilst the hospital isn't within the settlement boundary of Pembury, it is part of the character around Pembury. It is the approach, it's part of the approach into Pembury.
It is part of the character around Pembury, and obviously we've had a discussion around the countryside and what contributes to the countryside there.
Thank you. So if the hospital is part of the character of Pembury and we're considering the merging of Tunbridge Wells and Pembury, then it is also relevant to consider the impact of the appeal site, the hospital, the garden centre and Pembury. It's not just down a straight line.
No, I think what we're dealing with here is towns merging. And it's the MPBF is quite clear on that, to assist to prevent neighbouring towns merging into one another. The documents produced by the council have defined what is a village. They've turned a village into a town, which is fine. I accept that, and I've accepted that all the way through. But we're talking about towns merging. This is not something that's happening. And as I said, the boundaries and the physical separation created by the A21 and the trees, etc., etc., etc. I mean, any perception of the two merging is nil.
So that I'm clear, considering Pembury merging with Tunbridge Wells, that's okay. You're happy to consider it as a town for the purposes of this assessment?
As opposed to a village?
Yes.
Yes.
So it's relevant to consider it for the purposes of.
I think Ms. Kirk and I are both, and the documents before us have all agreed that it's a town, not a village, in that sense.
But then you say we're dealing with towns merging, and so you're looking at the boundary of the town only.
Looking at the boundaries of the town, that's what the town is.
But if there are features outside of the town that are part of the character of the town, then those are also relevant, aren't they?
Not in terms of the MPBF in those terms, but as I say, they're entirely separated. There is no intervisibility. So it's a sort of double whammy going on here, insofar as it's not a town. We're not dealing with towns merging. There is the physical difference is a very small percentage, but almost more important than that is the fact that it's so well isolated. The two are so well separated. There is no visual perception of the two merging whatsoever. I think you could agree that if you stood on the site, you would not see Pembury, there would be no perception of the signs merging.
It's not just about visual perception, is it?
No, but you have my position in my proof, and that's where I stand. There would be absolutely no perception of the towns merging whatsoever.
Can you please turn up your paragraph 7.6.2? 7.6.28 in that. You quote here about the 8264 from the Council's Greenbelt Strategic Study, but the A264 Pembury Road connects the two settlements, so retention of openness in its vicinity is important. And you say there would be barely any visibility of the appeal site proposals from the Pembury Road. Now, you imply here that the site is not in the vicinity on the grounds of visibility. Yes, if I understood that correctly.
Sorry. The point I'm making here, which links with the following paragraph, is exactly the point we've covered several times with myself and with Kirk, which is this business of Pembury Road, the connection which TW5 draws, the land use consultants document on TW5 draws, which is that there's a connection created by, as you move along the Pembury Road, by the perception of those fields to the left. The point I'm making here is that this does not apply because you cannot see the site from the Pembury Road, and it's in my paragraph 7.6.29.
Yes, and so the question I want to clarify with you, Mr. Gibbons, is that whether what's in the vicinity for you, visibility is relevant to that.
Yes.
Thank you. And then can you turn up the assessment for TW5 again, please, 052205.
Have it.
And so we're looking at the paragraph about relationship between settlement and countryside here.
Yeah.
We're about halfway down. The A21 that's containing tree cover, which prevents any intervisibility between the two settlements, is a key element in settlement separation. But the small size of the gap and the connection provided by the A264 mean that the open space within the parcel also makes an important contribution to the settlement gap. Now that refers to the parcel which includes the appeal site, doesn't it?
It does, but I've covered this endlessly that you can't see the appeal sites on the Pembury Road. There is no sense of that within the gap, but what you're looking at is the fields adjacent to the Pembury Road. And it's my reading of this is that is very much what they're talking about when they're talking about this connection and the effect on the gap.
They could have said that if that's what they wanted to say. They could have mentioned.
In my evidence.
Let me finish, Mr. Gibbons. Let me finish. Sorry. Because if you look at the paragraph at the top, development/land use, for example, where the block of trees in the northwestern corner is being discussed, they have specifically mentioned the northwestern corner. Now here they could have been specific, but they haven't. They've been very clear that it's the open space within the parcel. So this assessment relates to the whole parcel, doesn't it?
The assessment does, and if I can take you back to my evidence, my proof, right at the beginning of my proof, I believe that when this was done by land use consultants, it has an error in it, and I've highlighted that right at the beginning of my proof in 7.3.10. I do not accept the premise that I say fields adjacent to the Pembury Road is the fields that they're talking about when they're talking about that connection. And obviously, I mean, clear again, I've said it in my evidence, clearly if one was to develop those fields immediately alongside the Pembury Road, one's perception of the gap and the gap between Tunbridge Wells as you're driving out along the road and Pembury would change. Our site, you can't see it, barest of glimpse in winter, perhaps, we've talked about that a lot. I absolutely 100% maintain that that is different from what's being talked about in TW5.
And then for context, can we look again at PE6 052202 PE6?
Yeah.
In this relationship section, it says there is significant development within the parcel outside the limits of development.
Sorry, can I just stop you? Relationship between settlement and countryside?
Yes. Yes. Woodland containment means that there is still a distinction between this and the main urban area of Pembury to the east of the A264, but the garden centre and hotel are close enough to the settlement edge to constitute an urbanising influence. The main body of the parcel is also strongly contained by roads, limiting its physical connection with the wider countryside. The gap between Pembury and Tunbridge Wells is narrow, but the A21 and associated tree cover strengthen perceived separation. This reference in this paragraph to the development, significant development in this parcel PE6 is not replicated in relation to TW5, is it?
No.
There is no reference to urbanising.
They're not talking in TW5 about PE6.
They're not talking about the same level of significant development in TW5 as they are in PE6.
No, they're not.
They're not talking about urbanising influences in TW5, are they?
You're going to have to just give me a moment. Yes. Right. Sorry, carry on. Could you repeat the question?
Yes, repeat the question. Doesn't mention urbanising influences in TW5.
Without reading it all, I will take your word on
that. No, just have a look at. It's not a very long document. Take your time.
Sorry, I'm trying to find the reference to urbanising influence because I'm struggling to find it. I know there's one somewhere in all this.
TW5.
No, but in the methodology or within the,
okay.
Which is why I was digging back.
My question relates to the assessment of TW2.
TW5 doesn't.
Okay, thank you. And on this one, we can see, can't we, in the table that contribution to Greenbelt purposes in LUC's opinion for TW5 is relatively strong.
That's what they've assessed it as, yes. And I made my point that I don't think that applies to our site because our site's not seen in the same way. It's the key thing in terms of them making that assessment, as I see it, is this connection along the A264 Pembury Road, which our site plays no part in.
Purpose C. We turn up the CD 0522, so not TW5, but the actual document.
Yeah, I've got that.
What document is it? Sorry.
It's the Tunbridge Wells Greenbelt Study Stage 2, but of course it's all in separate.
Now I've got it. It's okay. Thanks. Just don't know the core documents.
And page 14. Then, Mr. Gidding.
I am.
Paragraph 3.28. No. All land that retains openness can be considered to some extent to constitute countryside, but the contribution made to safeguarding the countryside from encroachment can be considered in terms of the extent to which land displays the characteristics of countryside, i.e. lack of development, and land uses which are associated with the countryside rather than settlement, and in its relationship with the rest of the green belt. Now, I think we can agree that the site is countryside, that it displays the characteristics of countryside, and that the land uses are associated with the countryside. And if we can't, we can go to various documents, but I'm hoping we can do it shorthand for that.
Country, just to recap, countryside in planning terms, yes, it certainly, I acknowledge in my proof that it displays the characteristics of countryside in terms of its in agricultural use.
Yes.
Yes.
That's characteristic of countryside, isn't it? And there's been sheep on there, haven't there? One of your aerial photographs shows the sheep on there.
Say so.
For your note, it's 0711 02 17, and we can see sheep on the site there. But it's not just when looking at it from that aerial or saying that it's in agricultural use. When you are on the site, it feels rural, doesn't it? It feels like you're in the countryside when you're on the site.
So, yes, it's a field, but it's also, you've got the Sandown Park next to you, you've got the A21 running past you with the noise from the A21. I mean, to me, it's that urban rural edge, peri-urban, whatever you want to call it. It's not deep countryside, for instance. In planning terms, it's countryside is outside the limits of built development. That's my position on it. I think I've made that clear.
Right, now the relationship with the rest of the Greenbelt. Paragraph 3.29 talks about urbanising influences. Urbanising influences, whether through development within the Greenbelt or an adjacent urban area, can limit the extent to which land is considered to be countryside. The extent to which an area of land relates to the wider countryside can also be considered to influence the extent of its contribution. Has guidance states that the most useful approach is to look at the difference between urban fringe, land under the influence of the urban area, and open countryside, and to favour the latter in determining which land to try to keep open. And then at paragraph 330, it says it's important to avoid the inclusion of landscape quality as a factor in this assessment, doesn't it?
That's the question the inspector asked earlier.
Yeah. Now, at your...
I think that quote sums it up. I mean, I say it's urban fringe. The past guidance is saying urban fringe. Look at the difference between countryside and urban fringe, land under the influence of the urban area, and open countryside, and to favour the latter in determining which land to try and keep open. So we are in the former. But I think it speaks for itself.
So I want to discuss with you this element of urban fringe. You say at your 7641 that there are no urbanising influences on the appeal site itself.
Yes, we've agreed that. I
Now,
mean, on the basis that the box isn't, yeah.
On the basis, yes, yes.
Put that aside.
But urban fringe, sites in urban fringe, and we discussed earlier that having a landscape quality element to judging urban fringe, but urban fringe sites often have some attributes on them so that they are considered urban fringe. They have some degradation or some features on them. This site doesn't, does it?
You mentioned quality then. Obviously, quality is not relevant to Greenbelt purposes, but I think this land is urban fringe because of its context. It sits on the urban edge. That in itself makes it urban fringe. It may not be degraded land. It's not brownfield. It's not, somebody dumped fly tipping on it or anything along those lines.
Yeah.
But it's still urban fringe land in that it sits on the urban fringe. It's adjacent to the A21. There's urban influences, which doesn't mean just visibility.
Okay, so the first thing you talked about was sitting adjacent to the settlement edge.
Yes.
Going back to the phrase "death by 1,000 cuts," because if every time a site adjacent to the settlement edge was considered to be urban fringe, there would be no end to this particular purpose, safeguarding the countryside.
No, because you've got to take that wider context and look, are there those long views, etc. What's around it? What's on the other side of it? In this case, we've got Sandown Park one side, we've got A21 and the hospital and stuff other side. The context is not of, we're not out in the wider countryside. We are in that urban fringe area. And I think the death by 1,000 cuts thing is, I understand the concern about death by 1,000 cuts, but that's our other sites. We're focusing on this site. I can't comment on other sites which I don't know about. So the death by 1,000 cuts thing, I think is I don't know how relevant it is to this. I don't think it's relevant at all, because we're not dealing with, somebody gave me 5 sites, said look at them, do a cumulative assessment. I would do that, but that's not what's happened here. We're looking at this site, the site in question. Whether the council releases other sites is the council's decisions on the merits of each case.
If you're in Sandown Park, to the east, you don't see the site, do you?
When you mean in Sandown Park, you mean, for instance, on the road?
Yeah, in the development of Sandown Park or in the road.
Development of Sandown Park, there is some visibility from some sites. Some houses in winter, it's very minor. Standing on the road, there is visibility where the connecting feature of the road and the track join. But there's certainly in visibility terms, the site is, and we've acknowledged that throughout our assessment and throughout our process, the site is, it is quite well separated, and that of course is a good thing from the visual impacts on people in Sandown Park.
If you're in the green belt and on the avenue, you see countryside around you. You don't say, I'm in countryside next to houses. You don't feel the houses when you're on the avenue.
I disagree. I think, how did you get there? You've either come over the A21, crossed the bridge, thundering road underneath you. You're in an area of urban fringe. You've got the avenue, which is, there's fields either side of you. That's countryside insofar as it's agricultural. And then you go into a suburban area. If you go the other way, you come out of suburban area. I mean, the last time I was on site, the road yesterday excluded, the road was thundering away on one side of me. I could hear mowers going on the other side of me in Sandown Park. I'm in the urban fringe area. That's where I am. The site has characteristics of countryside. Of course, we've agreed that.
If the site's contained by the A21, contained by trees on the site and north, east and south, and within the fields that lie between the site and the Pembury Road, if it's so contained, then either it's contained from the countryside, Mr. Gibbons, or it must also be contained from urban influence. It can't be both.
No, I disagree. Influence does not just mean visual. Influence means, it's the stage 3 assessment process separates visual from urbanizing elements. And that's deliberate because they are different, exactly what we've been discussing. Yet, I fully accept that standing on the site, looking towards Sandown Park, there is limited visual connection there. That's plain, the inspector's been on site. But there are urbanizing influences around it, and I think we've been through this. Also, I would take it to the point of wider countryside. What we're looking at here, and we've referred earlier to the stage 2 assessment methodology, where it references wider, and those connections to the wider countryside. Are there the visual connections to the wider countryside? I've used a slightly poor analogy of looking across a valley to something in the distance or whatever. The wider, there are no connections to this site to the wider countryside.
There are physical connections, aren't there, to the wider countryside?
There are physical connections to the rest of TW5. That's to the south and to the north of the woodlands, but they provide they also, it's not just about physical connections, it's about containment. The methodologies talk about connections and separation, and you have to look at both of them. So it is the nature of this site is its containment, its separation from the wider countryside, which is why it has less influence on the wider countryside. There aren't those visual, and again, if we took away all that vegetation, etc. And you could see for miles and miles and miles across the high weald. Obviously, the connections would be vastly different to what we have on this site.
Yeah, visual. And then in your 7.6.46, you pray and aid the section beneficial use of greenbelt within the stage 2 greenbelt study. Can we just have a quick look at that, please?
I have it.
I think that is core document. Hold on a moment, it's just opening, sorry, sir.
So it's core document, it's the stage 2 greenbelt study CDO 522.
Yeah.
And the footnote, if I've got it right, takes me to page 34. Is that right? 6.2. Have a look.
5.19 I've got.
Maybe I'll look. Let me just.
Yeah, page 34 in the printed pages.
Okay. It's in the third box down in the table 6.2 there. Is that right?
No. Sorry. So this is paragraph 6.4, we see that the NPPF suggests types of beneficial use. They relate principally to the environmental quality of the land, but can also, through strengthening boundary buffer rolls and affecting landscape and visual character, affect the contribution of land to greenbelt purposes. And then it says that as part of its recent white paper on housing policy, the government has proposed that local authorities should seek to offset the removal of land from the greenbelt by way of compensatory improvements. This is about a completely different part of looking at environmental quality of the land in terms of beneficial use of greenbelt, and isn't something to be relied upon when looking at purpose C, is it?
I think the point I've made is fairly clear to the inspector. I mean, it says there, and I quote, a stronger visual relationship between countryside areas, whether directly adjacent or separated by other landscape elements, can increase the extent to which an area is perceived as relating to the wider countryside. In this case, we've got the reverse of that. We have very little perception of the wider countryside, so it decreases the perception of relating to the wider countryside. That's the point I'm making.
Now, last document I want to take you to, please, and that's 0625.
Can you tell me what it is?
Yeah. It's the Westmoreland decision letter again. When you're there.
Sorry, I'm there.
Paragraph 12. Last sentence, the appellant was relying on the site's visual containment in view from public places. Do you see that?
See that?
Paragraph 14. The development will be on undeveloped land, formerly in agricultural use, outside the defined settlement and adjoining other open land. That applies to the appeal site here, doesn't it?
It does.
And then it goes on. Paragraph 15, harm to openness and encroachment into the countryside must nevertheless be distinguished from other landscape and visual effects, which the council does not object. So this was a decision letter in which visual containment was being prayed in aid. But nevertheless, in paragraph 14, the inspector finds that it would result in encroachment into the countryside, contrary to one of the framework's purposes. There can be visual containment, there can be encroachment into the countryside, can't there?
Yes, and within my group, I've not said there isn't. I've said, I've made some judgments on the relative, and in this case, we're looking at a relatively weak contribution. I don't know the merits of all these individual cases either, which is, leaves me, that's what it says here, and I agree that's what it says. But
in relation to all the 4 purposes that you've assessed, for all of them you have found a limited harm, you're saying 7.7.2, limited harm to all 4 purposes, including land in the greenbelt.
That's what I've assessed, yes.
And harm to openness as well.
Yes, we accept that there is harm. It's, I think Miss Kirk summed it up very well earlier when she said, we agree there's harm. What we disagree with is the level of harm. And my colleague, Miss Miles, will deal with the very special circumstances that outweigh that harm.
Thank you very much, Mr. Gibbs. Those are my questions. Thank you, sir.
Thank you very much, Ms. Lambert. I don't have any further questions.
Thanks, sir. I just have a few. Whilst we're at lots of decision letters were put to you, the paragraphs out without context. Let's just have a look at the last one that the council were, through their advocate, was relying on. And you were taken to paragraph 14. That decision letter, if you've still got it out.
Have I got it here, sir?
And then can we just look then, because at the end, it was put to you that you'd found low levels of harm. Can we just see what the inspector found in the decision which council thinks is relevant to this decision? Paragraph 15.
Yeah.
And you read the first part of paragraph 15 by Maloney Friend, which you agreed with. Can you just tell me then what the inspector found? There was also, I think, beyond a railway line as well.
Yes, I just noted that.
Yeah.
Paragraph 14, it says, and beyond the railway line.
Yes.
Clearly, that would act as a separating feature, whereas with us, we've got the A21 on the outside of our site.
Yes. Can you just then see what it says in relation to visual effects?
Paragraph 15.
Yes, same paragraph. Well, you can start actually from based on the indicative
Based on the
layout.
indicative layout and scale, I agree with the parties that the site's relative containment and opportunities for retained and improving landscape mean that there need be no significant harm to landscape character. In relation to visual effects, whilst there would be some adverse effects on the currently open and undeveloped views as seen from adjoining residential area, the railway and the public footpath, I do not consider that these would be significantly or unacceptably harmful.
Can you just note what the outcome of that appeal was?
The appeal is allowed.
Okay. Can I just then put some other points to you? I think you've dealt with urban influence. You were asked about the growing periods of trees. You've given an inspector have a note of. Can you help me with this? Are you aware in the council stage 3 assessment you referred to whether they assess the number of years planting would take to grow?
No, I took the inspector to a page reference on that. They simply no, I mean, the example I gave was on the stage 3 assessment, page 97, paragraph 4201, and it says that and the proposed landscape buffer to the south will limit any potential impact on adjacent greenbelt to the east. So there's no time frame on that. They're saying, they're making their judgments based on a landscape buffer. There's no time frame, and that's been the council's approach through the stage 3 process.
So can I turn then to the question of permanence? It was put to you, this is not a temporary development. Has there ever been any suggestion or any doubt in your mind as to the permanence of what's being proposed. It wasn't extra care that would be sort of dismantled after.
No.
I mean, so far as you're aware, has there been any indication that the council were under the impression it was temporary in their assessment?
No, I think we're all quite clear on the fact that
Do you find in the council's assessment or in Mrs. Kirk's assessment, in terms of spatial impact, it being broken down into the fact that it's permanent? Is that expressed anywhere in the assessment that you saw?
No, I've not seen anything like that.
Do you find it was also put to you as well when you expressed the development was descriptive again? You accepted, obviously, a care home will have people coming to visit it and car parks and things. But again, if you're taken to task on not having expressly set it out, is it set out in the council's evidence anywhere or part of their assessment, a separate assessment of impact of visual impact? But just picking that up, it was then flipped the other way when you were talking about urban influence. The urban influence, it was being suggested to you, couldn't exist on the site because you couldn't see it. So it's the reverse argument that's been put, you were criticised elsewhere, too visual. Urban influence by other land, does that involve a degradation of the quality of the land? So you spoke about fly tipping. Is that something to take into account?
If there'd been fly tipping on it, then I'd say yes, there would be as a degradation on the quality of the land. But Greenbelt is obviously focusing on Greenbelt, not quality.
It's about Greenbelt. So in terms of urbanising features, you mentioned noise from the A21
Yes.
questions. Do you need to be able to see something in order for it to have an urbanising effect? Okay. Oh yes. The role of dual carriageways. You were taken to stage 1. I think we've already been to that. In stage 3 of the I think you already took us to it. Stage 3 of the council's assessment, I think it's paragraph 3.26. Already been to that. There, how do the council then, when they're doing the stage 3 assessment, look at dual carriageways and roads?
First bullet point under 326 on page 19 of that document is talking about strong boundary features, and it says at the end of the first paragraph, for example, dual carriageway. I mean, a dual carriageway is clearly a strong boundary feature. It also talks about multiple features increasing distinction, i.e. increasing separation. And in this case, we've got dual carriageway cutting trees along the dual carriageway as well. So we've got multiple features. So it's a very strong boundary.
Thank you very much, Mr. Gibbons. Thank you, sir.
Thank you, Mr. Jones. Thank you. That concludes. Thank you very much, Mr. Gibbons. Thank you. Are there any matters that any of the advocates wish to bring to my attention before we close?
No, thank you, sir.
No, thank you, sir.
No,
Yeah.
thanks, sir.
Thank you. So we'll close now. 5:10. Is it worth us just looking at the council chamber for tomorrow? Is it worth us just looking at it now? In there to do a
I think so. So particularly if the witnesses, I think, I'm trying to think. You might know. Have you done? I've only done
EIP.
EIPs.